is actually we could not circulate the adjournment slip. Actually, yesterday evening, Senior Counsel Mr. P.K. Tiwari was admitted to hospital due to UTI.
Okay.
So, Lordship, the matter could not be heard.
15, huh?
Yes, Lord. 5.
Ah. So
We
we'll
have taken the consent of the other side.
be here till 11th. So when do we keep it?
But
On the reopening?
yes, Lord.
Yes, it has been submitted on behalf of the learned senior counsel appearing for the respondents that he is not in a position.
Petition.
For
Yeah.
the petitioner, that he is not in a position to attend the proceedings today. Full stop. With the consent of the counsels for the respondents, list this matter again in the month of January as a part-heard matter.
Obliged.
We are not
Highly
fixing a date,
Yes.
whatever we are.
May the Lord. Also, I beg to mention item number 11.
11.
11. Also, with the consent. With
The
the
matter
consent
has to be taken up. It is of 2022. Anything prior to 2023, we'll take up the matter and we'll accommodate you if necessary. But it has to be taken up.
Lordship, we are being led by senior counsel.
No issues. You tell me that when the matter is called.
Much.
Yes.
May I please? I beg to mention item number 51, matter.
51.
51. I have taken contact from the petitioner side. Sir, kindly adjourn the matter, sir.
It's of 2015. Give us a reason why we should.
My lord, my senior teacher page has request application, matter. My lord, the next date, my lord.
Next week?
Sir, after vacation.
2015 matter, we can't keep it for so long. These are coming up because it's 2015. 10 years down the line, someone is waiting for an adjudication.
Kindly after vacation.
A mention has been made on behalf of Mr. T.H. Hazarika that he is not in a position to attend the proceedings today. Stop. The matter relates to the year 2015. Stop. Reluctantly, this court grants the adjournment and directs that the matter may be listed in the month of January on a date to be fixed by the registry for hearing. Stop. Parties are requested to prepare for disposal. Yes.
Lord, with the consent of the other side, I beg to mention item number 18, Lordship. And for the respondent number 2, we have to file our affidavit.
A request has been made on behalf of the learned counsel for the petitioner, or by the learned counsel for the petitioner.
Respondent, Lord.
For the respondent.
Number 2.
Respondent number 2. For an accommodation to be allowed to file the affidavit in reply.
Sir.
You are appealing for respondent 2 to file the affidavit in opposition. Stop. Learned counsel for the petitioners do not object to the same. List this matter again after 4 weeks, by which time the respondents shall ensure completion of pleadings.
May it please my lord. My lord, I am praying for accommodation with respect to item number 22, my lord. The consent of the other side. Here our instructions are awaited, my lord.
Learned counsel appearing for the Finance and Taxation Department has prayed for an accommodation as they are awaiting instructions from the department. Learned counsel for the petitioners do not object to the same, and therefore let this matter be listed after 3 weeks on a date to be fixed by the registry. Yes.
Lordship, I'm appearing for the petition in this matter. Your Lordship, there is an interim order that may cut.
The interim order passed. Earlier shall continue.
Much obliged. May I please the Lordship? I beg to mention item number 40 of the daily list, Lordship. Conducting counsel, Mr. P.P. Datta is out of.
It's a contempt matter.
Matter may be taken up next week.
On the request of the learned counsel for the petitioner, list this matter in the next week.
Much obliged.
May I please, your lordship?
Yes.
I beg to mention item number 12 and 14 with consent of other side. Matter may be taken up next week.
Let the matter reach. Let the matter reach. We'll accommodate. Don't worry.
May I please? Lordship, I beg to mention item number 26.
So in this matter, the senior standing counsel and Income Tax Department, Mr. Akita, is out of state.
Hmm.
And the matter will be taken up after 2 weeks. Okay?
You
And in
have-
the meantime, we file our affidavit.
You have informed the other side? The learned counsel appearing for the department has paid for an accommodation for 2 weeks.
2 weeks.
2 weeks to enable them to file the affidavit in response to the writ petition. Prayer not being objected to by the learned counsel for the petitioner, list this matter after 2 weeks on a date to be fixed by the registry. The interim order passed earlier shall continue.
May I plead your lordship?
Hmm.
Lordship, I beg to mention item number 8 and 39, my lord. That are-
8.
My lord, 8 and 39,
8, we will not take up. What is 39?
my lord. That may be list after 2 weeks, my lord.
You are appearing for
Petitioners, my lord.
on a request made by the learned counsel for the petitioner, list this matter again after 2 weeks.
Right.
Yes.
My
lord,
I beg to item 4. Actually, to close the,
Huh?
to withdraw the
Okay.
item 4.
Mr. M.R. Khandagad and a counsel appearing for the petitioner has submitted that he is under with instructions not to press the writ petition in its present form. Full stop. Accordingly, the writ petition is closed as withdrawn.
Lordship, I would like to make item number 18,
18.
18
Yes.
in the addition column.
18 mentioned. It has been mentioned and we were told that you are appearing for whom?
Mr. Jacob,
It has been mentioned on behalf of the respondents saying that your consent was taken.
oh, yes. Please, your lordship, I beg to mention item number 21 of the daily list.
Ah,
Lordship, a
Yes.
similar matter is pending before the Supreme Court. Your-
you tell it to us when the matter reaches, because we'll have to quote the Supreme Court order or
Yes.
the this thing.
Like-
Tell it to us when the matter reaches. Yes. No, give.
Daily list, item 1.
Mr. BP Sinal and a counsel appearing for the petitioner has prayed for permission to withdraw the writ petition in the present form. Full stop. Prayer not being objected to by the learned counsel appearing for the respondents, this writ petition is closed on withdrawal. No liberty. Okay. Attendance to the company.
Item number 2, for motion.
Yes.
Similar order, is annexed already. They will prefer a statute to appeal. Put out.
On the last occasion, देखिए, heard Mr. So-and-so. And for the petitioner and then Mr. So-and-so, learned counsel appearing for the respondents. On the last occasion, on 1/12/2025, the learned counsel for the petitioner had submitted that this matter is covered by the earlier judgment passed by this court in WPC number.
My lord, it is not even in the repetition itself.
Page
Yeah.
96 it is there.
92.
88 it is there, 96 also there.
Kindly tell us the number.
4543 of
4543 of 23.
4543. Full stop. The learned additional advocate general was granted time to have his instructions. Full stop. Today it has been submitted that a similar order would cover the grievance of the petitioner also. Full stop. In view of the submissions made, this writ petition is disposed of
Para 8 and 9.
in terms of the orders passed in WPC number so and so, which para, where the operative part of the order, reads as follows, para 8 and 9 from page 98. Writ petition accordingly disposed of.
Para 7.
Para 7, 8 and 9.
Para 7.
Para 7 is the earlier here. Lot
Para 7, 8 and 9, it
Yes,
will not
yes.
cause any
Yes.
distress to him.
Lord,
God bless you.
Yes. Yes. Mr. Islam, scrollটা দি দিয়ক। Scrollটা দি দিয়ক, এইটো ক্লোজ কৰিম। After some time. Petitioner কাৰণে scrollটা দি দিয়ক।
See, may it's taken after some time, the previously on the first time.
item 6.
Every date was not there. If respondent supposed to file an affidavit lordship today, but they have not filed last provision also they second time lordship.
Just a minute. PWD. Mr. Gogoi was here. Maybe he has gone to attend some other.
Something that immediate details is also not here, lord, to the lordship. Only take up the matter on Monday, lordship, if not inconvenient, lordship.
Monday, you may not have this bench. Have you seen the roster given in the notice?
As per lordship, convenient lordship.
Yes. Something to argue or? Something to argue, or do we say that it is admitted?
No, that approval is not. That's
Huh?
the inspection matter. I got the record. for-
Which
that-
approval
that's
is
the
not
notice.
there?
That my lord, drawing my lord, new drawing of that my lord causeway.
Ah,
That my lord, so the drawing was approved,
ah,
but the estimate was never approved. And it is a my lord, entire process will be completed when the estimate will be approved by the authority, and then my lord, the direction will be given to the contractor to proceed with the additional work. Here the drawing was approved, but the estimate was never approved.
and how did he proceed with the work?
That my lord,
No,
he
but
knows
some officer must have given him something.
that part, my lord, there is
If
no
some-
such document, no such document.
He is praying for the matter to be taken up on Monday or some other day because Mr. Das is not there.
And I'll ready with the record. Then my lord, on Wednesday, not on the hearing.
We are not here. I am on a criminal bench.
As per post
Huh?
lordship availability.
At the request of the learned counsel appearing for the petitioner, which is not being
In January,
which is not objected to by the learned counsel appearing for the respondents, list this matter again in the month of January on a date to be fixed by the registry for consideration. Huh? In the admission column.
Got
ठीक है?
okay.
Upod likhibo, although this matter was was directed to be listed for final consideration, at the request. Habo? Tabisot by khini ahibo, huh?
Item number 7.
Yes.
My lord, this matter pertains to my lord non-payment, my lord, by the ESIT hospital for supplying open my lord CRSD my lord fluoroscope machine. Herein my lord, as part of my lord the condition laid down in the JAM, my lord, now there is a clause in the guideline and terms and conditions, my lord, and after generation of the my lord, herein that after that lordship may kindly turn the page 44, my lord.
Page 44.
44, my lord. That is the
Yes.
installation report, my lord. The
Ha.
that my lord, the machine has been my lord properly installed. Thereafter, that my lord, the respondent authority has verified, and my lord, they have my lord given my lord their compliment that is that it is satisfactorily working. Thereafter, my lord, lordship will on 46 page 46 annexional, my lord will find that is my lord consignee receipt and acceptance certificate. It is CRST. So, matlab, they have already that the buyer has already issued the CRST, my lord, certificate. Now, lordship may kindly turn the page 72, my lord.
No, who has
Dhanjit Sharma, the petitioner here, my lord.
no, who has given you this annexure 9?
My lord, that is the, my lord, ESI hospital.
This is a computer generated statement to generate e-bill by the buyer for making payment. Okay.
That has
Then?
been uploaded in the online. my lord.
ठीक है, फिर then?
That has been uploaded online. Now, my lord, as per the terms and conditions laid down in the, my lord, in the contract, that lordship will file on page 72. That, my lord, after uploading the CRRC within, my lord, 10 days, after uploading, within the period of 10 days, that the buyer has to make the payment.
Okay.
But herein they have not made the payment.
Why? They
My
must
lord,
have some reason.
My lord, subsequently, and my lord, there is another condition that after, my lord, installation of the, my lord, that machine, the CRSC has to be issued within, my lord, 10 days, but they have not done this. After expiry of 1 month, they have, my lord, issued the CRSC. So, my lord, whatever it may be, that the clause says, my lord, that after uploading the CRSC, my lord, in online mode, the payment has to be made. And they have given the report. My lord, subsequently, my lord, they are taking.
The allegation in the affidavit of opposition appears to be that you had given them a defective machine,
My lord.
which performed on the first day and thereafter it did not perform anything.
Yes, my lord is correct. My lord is correct. So, my lord, the machine is under comprehensive, my lord, warranty. So I am the supplier only, my lord. I have, my lord, purchased the machine from the, I am not the manufacturer, my lord. The BPL authority. We are making the BPL as in party also. Now, my lord, that has been, that resolution they has taken after expiry of, my lord, that, my lord, that the 10 days tenure, within which period they are required to make the payment, my lord. So, my lord, we have also communicated to them, my lord, that resolution. Suppose, my lord,
Who appears for the respondents?
respondent, my lord,
The moment there is a dispute,
my lord.
whether they should have made payment on this day, that day, whether they can make a payment, whether they should claim it from the BPL and all. Should we
Otherwise,
enter into
my lord, my lord is correct. Otherwise, my lord, there is a, my lord, condition is there laid down. They are violating the conditions laid down that therein. Suppose, my lord, if, my lord, in compliance of that, my lord, guideline, if they, my lord, have already made the payment, if my lord, that subsequently they had come to the knowledge that there is some
have
defect.
all the parties appeared?
My lord, yes, my lord. All parties are represented appeared, my lord.
4
4 is also, my lord, there.
4 is represented by whom?
What is dependent on some earlier office of Professor my lord hearing.
Okay, এইটোত আকৌ স্ক্ৰলটা দি দিয়ক, স্ক্ৰলটা দি থক, ৰেছপণ্ডেন্সৰ কাৰণে আহিব লাগে। We'll have it after some time.
My lord.
Are you appearing in this matter?
Yes, my lord.
Yes, tell us. It item কিমান? 7. Yes.
Yes,
You are appearing for whom?
2 and 3, my lord.
2 and 3. Yes. Why
Yes,
are you not making the payment?
My lord, the petitioner supplied a defective good, my lord. Defective good, my lord. The lordship may see their affidavit in opposition, my lord. Web days. The manufacturer of the committee, the manufacturer of the company, they have also stated that the product which they have supplied has not been working. We have also been giving intimation.
Sir, tell us one thing.
Hello.
You are a consumer.
Hello.
You have ordered something.
Hello.
Someone has given you the supply.
Hello.
He is a supplier.
Hello.
He has given you the supply.
Hello.
Getting the things replaced, not working, everything. This is all with the company concerned.
My lord.
Supplier, why he is not getting the bill?
My lord, as per the agreement, my lord.
Where is the agreement? Show us.
Yes, my lord. If your lordship may come to page 71, my lord.
71.
One of the petition.
Yes.
And this is
Yes.
my lord, 3 and 4, my lord, if I may read.
Page 71.
72, my lord, the relevant.
Page 72. 3 years.
Is buyer concerned right of rejection, my lord, clause 11. 3, my lord. Sorry, my lord, 4. On payment, no payment shall be made for rejected goods or services. After intimation of the rejected part rejection by the buyer, consigning, the seller shall be liable to remove, leave back such rejected goods within 10 days without any extra cost, a charge cost to the buyer, consigning failing which suitable ground rent, warehousing charges would be payable by the seller to the buyer consignee. If the seller fails to remove, leave back such rejected goods within reasonable time period, the buyer, the consignee shall have the right to dispose of such rejected good, the risk and cost of the seller. And my lord, there is also one clause for arbitration, in the same agreement.
Very well. Read 2.
My lord, for services.
Read 2 above 4.
Yes. On acceptance, part acceptance or rejection of goods, services, consignee will issue online consignee's receipt cum acceptance certificate, which will form the basis of payment to the seller. Yes, my lord. That's the my lord. If
My
you
lord,
lo-
on
Number 1. Please read
Well-
number 1.
My lord.
Number 1 on the earlier page.
Yes, my lord. The goods delivered shall bear the self-certified manufacturer, sellers, warranty guarantee buyer. Consignee shall have the right to inspect the supplied goods themselves and or through their appointed agency at consignee's own cost at consignee's site after receipt of the accept or reject. On proper justification, any consignment of the goods received within a period of 10 days of receipt of consignment of goods.
Now show us your rejection.
My lord,
Where is your rejection? When was the good delivered, sir?
on 16/7, my
16/7, yes.
16/7. Thereafter, my lord, it has
Just
been,
a minute, we have asked you only one question. Restrict it to
My
that.
lord.
Yes.
my lord, if Lordship may give some more time because this matters,
At two.
I have received, my lord,
At
by
two.
Monday, my lord.
At 2.
And I have actually the corporation and the medical superintendent, the two both entities, however, we are representing the same, only one. I'm thinking only on
We
Monday.
just need to know if you have rejected it within 10 days,
My lord.
we dismiss the writ petition.
Okay.
If you have not rejected it within 10 days, we allow the writ petition. Plain, simple.
Okay.
Tell us at 2.
My lord, that is-
When was the goods delivered? When did you reject it?
on this instruction, my lord, I have
And
to
when did you accept it?
My-
Acceptance I can show you.
my lord, that. But
Shall I assist you on that?
no, but I'm
Huh?
speaking only, my lord, just a word. One this time, but to receive instruction from the medical superintendent, my lord.
No, this is of 2000.
22, my lord, yes, my lord. This matter is an old matter, my lord. This
Yes.
earlier planning council was, my lord, handling this matter. Only, my lord, seeking just one
You
day.
filed your affidavit in opposition, sir.
Yes, this opposition is.
Number 1. Number 2, the terms and conditions you're taking us through, why we are not inclined to give you time, we'll tell you very frankly. You tried to make us read clause 4. Clause 4 is dependent on clause 1. You tried to mislead. Not happy. At 2. Had you not referred to clause 4? Or had you referred to clause 1 earlier? Or had you made an argument that it's a defective piece and this is government and we cannot entertain this? We'd have listened to you. You tried to make us read 4. You skipped 1. And therefore at 2. At 2, kindly tell us the date of rejection. Kindly tell us the date of supply. And kindly tell us the date of acceptance. And then show us that you can hold up the payment to a supplier if the product is bad.
For that only, I'm seeking, my lord.
You have to show us from the contract. Ask them to come over, ask them to brief you today. Yes, next. 8. 39 I allowed. 8 I did not. 8 অলপ দেৰিকে মাতিব, স্ক্ৰল দি দিব এইটো অলপ পিছত, হা? এটা মেটাৰত কোনোবা আহিব, নেক্সট মেটাৰত স্ক্ৰলটো দি দিব তেতিয়া। 8টো পিছত ল'ম। Item number 9.
Please, the Lordship.
Yes.
My lord, the petition pertains to termination of the contract of the petitioner, my lord,
Ah.
awarded by the railway. The basic issue is that, my lord, after award of the contract, in the tender conditions, there is a provision of variation of the scope of work, my lord, variation in quantity as well as material. So, the petitioner approached the railways authorities. Once it has been granted, the variation has been granted, my lord. And subsequently, he again approached, my lord. Without considering his claim, my lord, the railway authorities has cancelled the work order, my lord. That is
Where
the
is the
issue.
variation clause?
Variation clause, your lordship will find at page 52.
52.
Yes, my lord. Page 52, clause 42 and 42(1), my lord. Once the variation has been granted, Annex 3, my lord. So 42, my lord. Modification to contract to be in writing. In the event of any of the provisions of the contract required to be modified after the contract documents have been signed, the modification shall be made in writing and signed by the railway and the contractor, and no work shall proceed under such modification until this has been done. Any verbal or written arrangement abandoning, modifying, extending, reducing, or supplementing the contract or any of the terms thereof shall be deemed conditional and shall not be binding on the railway unless and until the same is incorporated in a formal instrument and signed by the railway and the contractor. And till then, the railway shall have the right to repudiate such arrangement. Powers of modification to contract. The engineer on behalf of the railway shall be entitled by order in writing to enlarge or extend, diminish or reduce the work or make any alterations in their design, character, position, size, quantities, dimensions, or in the method of their execution, or in the combination and use of material for the execution thereof, or to order any additional work to be done or any work not to be done, and the contractor will not be entitled to any compensation for increased reduction in the quantities of work, but will be paid only for the actual amount of work done and for approved material supplied against a specific order. So in terms of this variation clause, my lord, once the variation has been granted, my lord, that your lordship will find that.
You prayed for a variation.
Yes, my lord, I prayed for variation.
What did you want? You want to do more work or you wanted to do less
My
work?
lord, some scope of work, some additional quantities.
Work you were required to do.
Yes, my lord. While performing the work,
On-
my lord, some nut bolts or some slippers, because it is re-specifying of slippers. And in our representation, we have right in details, my lord. What?
Now, where is that first grant?
My lord, first, my lord, the variation was
Allowed?
granted, my lord. Annexure 5, my lord.
Annexure?
Annexure 5. So this is first interim variation statement. My lord, in respect of some of the items, in respect of item number 1, that is the negative variation, my lord, because less quantity was, and my lord, in respect of my lord, item number 2, then E1, E2, and in respect of item number 3, my lord, the variation has been granted, my lord.
Page number?
Page
Fine.
number 120, my lord, annexure 5. Now, in their affidavit, my lord, they are saying that variation in quantity only can be granted, but variation in material cannot be granted. But as per clause 42(1), my lord,
42(1).
yes, my lord, 42(1) says that the materials also can be granted, my lord.
Where did we read that? Yes.
42(1), page 52, my lord.
Where does it say? Yes, so you are saying that since you wanted a variation in the material.
Yes, ma'am. Some additional materials are also required. Not also that type of. Yet we have
Which was not included in the original contract.
Yes,
You
ma'am.
you did not include those nuts and bolts in the original contract.
yes, ma'am.
Now you need to include them.
Yes, ma'am. And that has been we have right in detail, my lord. Page 7, my lord. Annexure 7, page 125.
125. They have considered it.
No, they have not considered. The earlier one considered and Annexure 5 that has been granted. But subsequently, we have filed this application, my lord. So here, my lord, we have specifically wrote why the variation is required, my lord. My lord, paragraph 3 writes from paragraph 2, my lord. In respect of this, I would like to say that several times of my officially letter and by verbally discussion to your office that item number 5 includes respacing of steel channel slipper exact spacing under traffic with contractors' own labors, tools and plans in all complete. Rate includes 1 round of initial packing the slipper, etc. Depths are the rate fixed by your NDs ₹49 per slipper, which is for only re-specifying of such slipper. But the work in re-specifying, which includes refixing of both, needs boring and have to lose almost 10 numbers of such fittings, which include hook bolts 2 numbers, guard bolts 4 numbers, T-bolt and nut 4 numbers, sequel plates. So in detail we have wrote, my lord. Why the variation is required, my lord. But they have not considered. Without considering, my lord, they have issued a notice at page 126, my lord.
Yes, requiring you to commence the work.
Yes, my lord. So,
You did not commence the work.
No, after this notice also, it was sent on 25/11. Then thereafter also we have write another at Annexure 9 on 29/11/2021. Again we wrote, my lord. Page number 127, Annexure 9. So why the variation is required? But without considering it, my lord, then again we have wrote another on 19/1/2022 also. Subsequently, without considering our grievance, my lord, they have issued the termination order at page 130, my lord. My lord, at least they should have considered it. But even in this order, my lord, nothing has been specified whether it has been considered or not.
The representation.
Yes, my lord. Now, my lord, otherwise the work has been completed by some other contractor. That is not. My only issue is the performance security, and performance security has been encased and security money has been forfeited, my lord. So, my lord, apparently, while performing the contract, some problem was there, my lord.
Two things will come. Two things are coming in the way.
Yes, my lord.
The first part is that the notice which was given to you,
Yes, my lord.
it was not a notice asking you to show cause. It
Yes.
was a notice that if you do not commence the work
Yes.
immediately,
Yes.
then we will terminate it.
Yes, my lord.
Now, you have not been able to show that you commenced the work, but you could not complete it because of the variation not being allowed.
My lord, in that regard, page 127 letter, my lord, there, if you read the last part, my lord, that for doing the re-specifying works, page 128, my lord. I have already purchased so item number so. And this invoice also I have annexed at page 131, my lord. We have purchased the materials also, my lord. Under the aforesaid circumstances,
That
it
is all well done. The query of this court is a little different.
Yes, my
I'll
lord.
rephrase it. The notice given to you at page 124 is
I understand, my lord.
that
Your
if
query,
you-
I
if you-
understand.
If you do not commence the work again.
My lord, then annexure 10, page 129, my letter.
Yes, please.
But now I want to continue the work at bridge number 20, the last two paragraph, my lord. So the work for re-specifying of steel channel slipper already completed at bridge number 24 with complete sets of channel slipper fittings with proper spacing. Further, the work was discontinued till today because of third wave of COVID pandemic. The item number 5 for spacing is not included in our agreement. For that, several times it was informed to the office to put such items in the variation. But now I want to continue the work at bridge number 20 because I bought all materials such as the required at that nominated bridge. So you are kindly requested to organize your schedule and let me know by letter of such so that I could able to continue the work.
Yes, Mr. Sharma. His argument that you have not even considered why
No,
he did
no,
not
that
complete it.
is not the issue, my lord. First of all, my lord, nothing survives in this description about them because the contract was awarded to someone else who already completed it, and the consequence of termination is, my lord, forfeiture of the amount.
That's right.
Now that has already been encouraged. Now, before I make my submissions on the merits of the case, my lord, but I'd like to draw your attention to page 72. My lord. This is not at all maintainable, my lord. There is an arbitration clause. Any dispute has to be referred to arbitration. Page 72, clause number 64(1). Demand, and that is my specifically in my affidavit in opposition. Clause number 64(1), demand for arbitration. In the event of any dispute or difference between the parties, hereto as to the construction or operation of this contract or the respective rights and liabilities of the parties or on any matter in question, dispute or difference on any account as to the withholding by the railway of any certificate to which the contractor may claim to be entitled, or if the railway fails to make a decision within 120 days, then and in any such case, but except in any of the excepted matters referred to in clause 63.1 of the conditions, the contractor after 120 days, but within 180 days of his presenting his final claim on disputed matters shall demand in writing that the dispute or difference be referred to arbitration. Now, in railway matter, Malad, it is an admitted position, Malad. In case of any dispute, during the continuance of the contract or even after termination, it has to be referred to arbitration. There is no other way. Now, so far as the
Where is that
allegation
accepted matters? Where is that part? Which are the accepted matters?
accepted matter clause 63,
Ah,
clause 63,
hmm.
page 71, my lord.
I read it. I do not find what is the accepted matter. What is accepted matter? I do not find.
Just a minute, I'll come.
Ha, yes.
Except Yes, lordship may kindly refer to clause 31. The entire clause has to be read, my lord.
Yes, yes,
Page
clauses 8, 18, 22.5, 39, 43, 245 is so and so of the standard conditions of the special conditions of the contract shall be deemed to be accepted matters.
Now he's claiming, my lord, return of the amount that has been forfeited. So it doesn't come in the.
For that, it has to be shown that it, even if you had terminated the contract, you would not be entitled to use it. And that is a matter of dispute which requires some evidence to be laid. Can we take it on record? Yes, Mr. Bora.
Yes, my lord.
What do you say about the arbitration part?
My lord, that clause has been already dealt with, that is by a coordinate bench of this honorable court. In respect of same conditions of contract, my lord, when there was a arbitration clause, my lord, because it says in terms of the judgment of Whirlpool and Horpongslal, my lord, it has been held that, my lord, the repetition is maintainable. Because apparently the fundamental right of the petitioner has been violated, my lord.
But here this court had found that the notice period had not been adhered to.
My lord, there was dispute was different. My lord,
That is what I'm saying. In that context, when the court found that the question put before the court was plain and simple.
Yes.
7 days notice.
Yes, my lord.
You do not do it. Another 48 hours notice.
Yes,
Then termination.
Yes.
This was not done.
yes, my lord.
So if this is not done, it's apparent there is nothing. There is no dispute to the entire issue.
Yes, my lord.
Whether you are entitled to a notice or not, whether all these were not in dispute.
Yes, my lord.
And it was admitted that you were not given the required notice. Therefore, this court said that alternative disputes redressal will not.
But my
Stop
lord,
the court.
when there is
In the present case, we have to find out whether that material was required to be considered or not, that variation can be allowed or not,
Yes,
whether
sir.
whether
Yes,
you are required to commence the work
yes, my lord.
and all that part.
Yes, they are basically
It is not a straight cut case.
yes, my lord. They are basically is that, my lord, the variation of the material cannot be allowed. Only the quantity, because in their affidavit they have.
That is the affidavit will go to later on.
Yes, my lord.
Your case is to stand on its own footing.
Yes, my lord.
Now,
In that case, my lord, the notice was given, but after the 7 days notice, my lord, the petitioner resumed his work. Without considering that, the 48 hours notice was
The
given.
work was resumed.
Yes,
Here,
Malord.
what do we have? We don't
Yes.
have that.
Yes.
Factually,
Actually, it's different.
so
but
therefore, there
on
it
the
was a
point of
question of,
arbitration, my lord. I am referring to
on the point of arbitration, the court held in that manner because the question was straight cut, if you see.
yes, my lord.
Here, the question is not straight cut.
But a basic the violation of fundamental rights, my lord. Because in the case of Whirlpool, my lord, when there is a violation of the fundamental rights of the petitioner, my lord, then, my lord, the writ petition can be entertained.
Not the fundamental right. It is a violation of natural justice. Your representation was not taken into account.
Yes, my lord. That is also not.
Fundamental right. I have my doubts.
And I intimated that I am going to resume my work, my lord. That also has not been considered, my lord.
So now, if the writ petition is limited only to the point where you would be allowed to, the consideration will be whether your what the
Performance-
performance
performance
security
guarantee
and
Security, man.
the other security deposit. These two are to be returned to you or not.
Yes, my lord. That is the only text, my lord.
For that, we have to decide whether the termination was correct or not.
Yes, sir.
That is attained finality, my lord, because the work has already been allowed to someone else and they have already completed the activity.
He would still be entitled to get back
Hello?
at least get back his deposits in case we hold in his favor.
Yes, definitely.
He will not be able to execute the contract or
Yes,
make any
that is
profit
not-
out of it. But what he had deposited with you,
That is a natural consequence of the termination. For that, people will have to hold that the termination was. Now, so far as the allegation regarding, my lord, variation is concerned, my answer to that is that variation in quantity is permissible. Variation in the rates that he have quoted is not permissible. What he was asking was variation in the rates. Lordship may kindly take up peruse paragraph 7 of his writ petition, my lord. Otherwise, we would have allowed, my lord. That is not permissible, the variation in rate. What?
the application that he had made,
Well,
you are asking for a variation in rate.
paragraph 7.
Mr. Bora,
Yes, my lord.
your application of 2021 says you are asking for a variation in the rate,
Yes, my
not
lord.
in the material.
Because when there will be additional material, obviously the rate will be, and that is up to plus minus 25% is admissible, my lord.
That is
The
in quantity,
page
not in the rate.
52, para 42, alter design, character, position, site, quantity, dimension, or in
Yes.
the method of execution or in the combination, and use materials. For example, when you said materials, we were a little convinced that materials can be allowed to be varied.
Yes.
But now we see that your prayer is that the rate should be varied.
My lord, at any rate, if my payer cannot be considered, they should have informed me. And lastly, my lord, even though, my lord, I intimated that I am ready to resume the work.
Oh yes, when did you say that you are not allowing the variation?
Nothing is there, my lord.
When did you refuse the variation?
Nothing is there, my lord.
That is not at all permissible. That is all.
Very well. Has he not to be told that we are not allowing the variation,
So you,
continue, or we scrap it?
That is why no notice was given, my lord.
The notice does not even
That is the procedure.
this letter.
that
If
notice
you-
is a standard format.
Just a minute, Mr. Bora.
Yes, my lord,
If
sorry.
this letter is not disputed by you,
Which one, my lord?
the application, page 125.
125.
If this is not disputed by you,
What?
then you have to perhaps show us. We will not say, even if we allow the writ petition, we are not going to the extent of saying that everything was wrong. What we will go to, what we will go to hold is that he was never answered. You want it after some time? You'd like to go through the letters and whatever you have
Yes.
given on record after some time? We'll have it after some time at 2. At 2.
My lord, can it,
If your prayers have not been answered, if your letter has not been taken into consideration at all,
yes, my lord.
that may give you a relief to the extent that
Security,
since
my
it was not
yes,
done,
my lord. That is my, can it be on Monday, my lord?
Monday, this court is not there, we'll have to take a chance. Yes. You want it on Monday, we'll have it on Monday.
Yes, my lord, at 2.
At 2?
Yes.
Why not? If that was not answered, he
Yes.
never had noticed that he will not be.
Probably that is not required. Let me have my instructions from my client.
Bless.
আপনার infusing material.
I don't know why.
Yes, Mr. Nair.
Please, it's a matter in which my residential property, my land and house,
Hmm.
was occupied by the Indian Army from 2008, my lord,
Hmm.
without any formal acquisition or requisition.
Hmm.
That is why I was before lordship. And during the pendency of this petition, they have vacated the property.
Hmm.
They have said so. They have admitted in their affidavit, both
Hmm.
the circle officer on behalf of the DC as well as the Indian Army. However, my lord, no compensation has been. That is why I am before lordship.
Vidya Devi.
Yes, my Vidya Devi, my
Vidya
Hima,
Devi.
as well as the others, my lord.
Yes,
Jilukai
sir.
and all.
Yes, sir. Mr. Nair wants to use your vehicle without paying you compensation or even filling the petrol. Will you allow it? No. Yes.
My lord,
Tell us.
here, in fact, my lord, the land was given to the authorities just for a counter-insurgency. Some operations were going on. EPC has handed over the land temporarily to the unit, the
Yes.
army unit, in the year 2019.
Hmm.
And in the yes, they were in possession from 2019, and thereafter in the year 2021, they have vacated the land to the deputy.
19, 20, 21.
Yes.
3 years. Yes.
So, Lord, here,
Hey.
word from the authorities, Lord, we have received no assessment, Lord, under what provisions under the company, because admittedly there is no acquisition of land. There is no acquisition process. We have not
There
acquired the
is
land.
there is a circular
Well.
of the Indian government, perhaps one for the estate officer of defense also,
Hello.
that when you fix a market rate and
Well.
when you do not pay the rent for some time, and when you do not vacate the quarters and you hold it unauthorizedly, first 3 months is marketed into 2,
Yes.
then it is marketed into 5, then it is
Well.
marketed into 7. Pay that.
But Lord, there is no assessment. My Lord.
Not required. We'll ask the deputy commissioner to assess the market rent.
That is what the instruction. My Lord.
Yes,
We'll see the
who
order
appears for
dated
the BTC?
22/1, my Lord. There is an
Who
order.
appears for the BTC? You? Yes, what is the market rent? Pay.
I obtained instruction.
When? When?
On the next.
4 years, no instruction.
Oh, yes.
What does your affidavit say? Mr. Nair, take your seat.
Mine.
What does the affidavit say?
Everything we have not filed,
Not filed.
not filed.
Ah.
Deputy Commissioner are 11 filed. This copy also I have filed.
Who is respondent number 11?
The Deputy Commissioner, right?
Who represents Deputy Commissioner Baksa? DC Baksa also you appear, madam? No, who allowed you to, yes, Mr. Gupta, who allowed you to, where is that letter saying that you are allowed to use the land? The authorities allowed you? By which letter? Page 63, yes. Hmm. Detailed brief.
It's your affidavit. Affidavit filed by respondent number 30.
Office of the Circle Officer, Jolor Revenue Circle, that one?
Yes. There is no objection.
No. This is the certificate saying that you did not damage it.
Well.
That you are allowed to use it.
No, the Army's affidavit says that they do not have any documents, man, to show that it has been handed
They
over.
do not have any
Any documents, my lord, the affidavit which my learned
To
friend
do
is.
what?
The land.
to
has been-
enter the land.
Yes. My lord, page 53 of the affidavit. Of the affidavit relied on by my friend. The original one was 46. Para 6, last line, my lord. No
Page
doc,
60?
page 53, my,
No, page 53, para 6 is not there.
my lord. Internal page 46, my lord, of R13's affidavit. Or that the land was taken in 2008 is
Ah.
admitted by the army authorities at
Can it be done this way?
my lord,
We'll take up this matter after some time.
my lord,
Perhaps Mr. Rahman can assist you.
my lord, my lord.
The pagination,
Is
if
the-
you have the pagination according to this file, I need not go through
My lord, my lord,
searching for
my lord,
pages.
my lord.
And in the meantime, Mr. Gupta, kindly find out that piece of document by which you were allowed to enter that land. If it was done in in emergent services,
Yeah.
because of the emergency nature of the services, then show us that you were directed by someone to occupy that piece of land. Thirdly, if there was nothing and you went and sit on that land, kindly go through Vidya Devi and the other judgments. Also tell us by when he can be compensated. 2021 matter, we are disposing it today. Because pleadings are complete, no further
Pleading
documents are
complete.
required here. We will dispose it of asking them to assess the market rate, use your, what do you call them? That the estates office memorandums, multiply by the market rate, pay whatever is required to be paid. Like you recover from people, you give back to the people. Is it not? Find out if you have got any order from the DC or from any other office allowing you to use the land. Then the liability will be transferred to them. And if it was without any return order, then I think Vidya Devi will come in. So when? Again at 2?
Fine.
At 2? Yes, at 2.
Deeply applied.
Item number 10.
Yes, sir.
Lordship, petitioner land has been acquired, Lordship, providing NS 37, Lordship. Lordship, but Foreign Authority, Lordship, denied their acquisition, Lordship. That is why, Lordship, petitioner applied for demarcation of his land, Lordship, so that that can be determined, Lordship. In earlier order, Lordship, this Honorable Court, Lordship, asked our Lordship in 18/2/2022, Lordship, order dated.
Yes, Mr. Sharma.
I'm praying for accommodation, Lordship. We have not received any instruction. Only one letter, it goes in the year 2022.
When can you have, when the prayer is for demarcation?
Lordship.
Huh?
Lordship, so that my land has been acquired, that should be.
So now,
Lordship.
now if your land is demarcated and found not to be within the acquired portion,
Lordship.
then your prayer number 1 goes at page 16.
Lordship.
Then the prayer number 1 can be abandoned
Lordship.
if your land is not acquired.
Lordship. Lordship.
And it is
Regarding
then-
demarcation, Lordship, he can make an application, Lord.
No, he has done
Already
it.
applied, Lord.
He has done it.
Lord.
And last 3 years that the case has
Lord.
been pending.
Lord.
The Deputy Commissioner Jorhat, District Commissioner Jorhat seems to be oblivious of the matter. And for the last 3 years, you also did not make any attempt to have the
Lordship.
matter listed. Yes.
Lordship, I have Lordship, after
After what?
Lordship, direction of the Honorable Court, Lordship, I have submitted it, Lordship, in Lordship,
What have you submitted?
Lordship, this order, Lordship, with it.
To whom?
Lordship, Deputy Commissioner,
I'm not on that. The matter was last taken up in 2022.
Lord.
Now you are coming in 2025.
Lord.
No effort on your part to have the matter listed. Is your petitioner still interested?
Interested lordship, the poor man lordship,
Huh?
very poor man lordship. And he
We do not know about the economical condition, but the services he is
visited-
availing
Lord,
does not appear to be
Lord,
very
it-
rich and encouraging.
visited the office lordship,
Huh?
but visited the office lordship, frequently visited
Why is the matter pending for 3 years?
lordship.
Huh? And even after January 2025, the matter has now come up in December.
Lord.
Huh?
On earlier occasion, lordship, this honorable court lordship, the pendency of the writ petition shall not be barred to Deputy Commissioner Joa to take note of annexure 2 series 25 and register demarcation case if there is no other legal impediment lordship. This order was also submitted to before. No action has been taken.
No action on your part has been taken is what we are
Lord.
said.
Some negligence is there.
Then, okay, although this matter relates to the year 2022 and
Okay,
notices have been served on all, there are how many respondents? On all the respondents,
Lord.
comma. Today, Mr. H. Sharma, Learned Counsel, appearing on behalf of the respondent number 3 has prayed for an accommodation by 3 weeks to have his instructions. Stop. He has submitted that the matter was last listed in the year was listed in the year 2022 and thereafter in the first week of January, and there are only few communications available in the record. Full stop. He submits that given an opportunity, the status of the applications filed by the petitioner for the demarcation and also instructions as to whether the land of the petitioner had been included in the acquisition process will be made available to this court without fail. Full stop. Acceding to the prayer of Mr. H. Sharma, let this matter be listed again after 4 weeks on a date to be fixed by the registry. No, let this matter be listed again on 3rd of February 2026, by which date Mr. Sharma shall ensure the availability of instructions both on the prayer of the petitioner for demarcation of his land and of the and as to whether the land of the petitioner was included in the acquisition process and whether the petitioner has been given due compensation in respect thereof. Full stop. Report ekdom likhiba heard Mr. A. Sharma, Learned Counsel, appearing for the petitioner. Yes, sir, get this 2022.
Lord.
Yes.
I am waiting for item number 8.
Huh.
My lord, I am appearing for private
Okay,
respondent matter.
you are for the
Private
respondent.
respondent
Yes, the petitioners had made a request in the morning for
Okay.
taking up this matter after some time, after some accommodation. Do you have objections? What is the matter about?
Matter about my lord, they are petitioner Alpha, my lord. They, my lord, applied for settlement of land,
Huh.
Kharpetia municipal board area. He then, my lord, in 2000, my lord, the Kharpetia town committee within the subdivision of Udalguri, my lord, Dorang district. But my lord, thereafter, my lord, it was included in Dorang district, excluded from the Udalguri district. But then, my lord, LTO, my lord, Udalguri, to the advisory committee, took resolution for settlement. And that my resolution become infractual because my lord is excluded from Udalguri, now included in the Dorang in 2000, sometime in 2006. And resolution of my lord 2000. My lord, page, kindly see my lord, page.
They are a cooperative society. They want some land.
Yes. They will cooperative, there.
You are appearing for whom?
Therapeutic municipal court. Initially, I was not included, but filing my lord, I was included.
Okay, they had made a request. We'll have this listed in the month of January.
No, I have no objection, my lord.
Huh. Miss Sensol and Council. Huh. Hmm. Hmm. We'll do what is required to be done. They had paid for a. No, they had made a request for the matter not to be taken up today. We'll accommodate them for the day.
Otherwise, also they will not get because my lord, Tuthalguri subdivision. Yes, yes.
Mr. Chauhan knows very well that even a dismissal without being heard is not
That's right, my lord.
appropriate.
Because
Yes.
not-
Ms. Swensel and council appearing for the petitioners has prayed for an accommodation, stating that the council appearing for the petitioner is indisposed today. Full stop. Mr. S. Chauhan and Ms. Burman appears for the respondents. Full stop. It is noticed that the affidavit in opposition had been filed in the year 2022 itself, comma, whereby it has been stated that the wherein it has been stated as follows. You take down para 4 of page 23, huh? Okay. Full stop. Although the matter relates to the year 2022 and or 2022, comma, giving an opportunity to the petitioner. List this matter again in the month of January 2022 on a date to be fixed by the registry. Full stop. It is made clear that no further adjournment would be granted. Yes.
But. 11.
Yes, 2022 matter.
May please, your lordship.
There was a request in the morning for
Right.
an adjournment today.
My lord. I leave it to your lord, my lord.
Huh? What is the prayer in the petition, madam?
Uh, may I just very briefly,
Yes.
in my limited understanding of the matter, your lordship, a recovery certificate under Section 15 of the Assam Tea Plantations Provident Fund and Pension Fund was issued to the petitioner. That was followed by respondent number 2. That was followed by an issue notice of demand by respondent number 5. Certain amounts were paid by us from time to time. In the meantime, respondent number 5 was given zimma of the property of the garden. The same was taken into possession by the private respondent. Now,
No private respondent here.
Umatara, respondent number
Added later on.
added later.
Okay.
Yeah,
Yes,
that's not
yes,
with the
yes,
option
yes.
precedent.
Yes, we find the cost title. Yes.
There was a sale auction, your lordship. And prior to that, the petitioner had issued a letter to respondent number 2 seeking for information regarding the bidders, the sale consideration amount, etc. In the meantime, there was the impugn public notice, which your lordship will find in page number 38. The respondents had issued a paper publication calling for financial claims from creditors. So, your lordship, our submission is that under Section 15, under the recovery certificate, they do not have the right to go beyond the ambit of that section. They may claim for provident fund and the arrears that are due, but then calling for financial creditors does not come under the purview of the Act.
Okay.
That is my limited understanding of the matter, lordship. However,
Now you are protected by any interim order?
no.
Huh?
No, that's a part of my already we don't get that notification, my lord.
Okay.
That has been recorded by this honorable court also. Yeah,
You were required to take some instructions. You have the instructions.
We have already filed our affidavit file.
No, but the orders of 20 of April 2025
Right.
and the order of August 2025.
That time we have already filed an additional affidavit, my lord.
Acha, thereafter you have filed the additional affidavit
Additional affidavit.
on September.
Yeah, ma'am.
No, you filed it on August and you have filed the reply on September. When you know the case so well, why do you need time?
Lordship, we are being led by senior advocate Mr. Didas. He's out of station, Your Lordship.
Point, my lord, whether this, we are authorized to adjust the, my lord, the other dues, my lord. Even except the even certificate amount, my lord. Whether we are legally entitled to adjust.
If it is convenient for you because of the absence of the
No, ma'am,
senior
that-
counsel on the other part, we'll have the matter fixed in
Yes.
February
But-
3rd, 4th, 5th.
There's some urgency in the matter on
Huh?
February,
February 5th is what I was saying. You want it before that?
a shorter date. After vacation, Your Lordship,
29th?
Correct.
29th?
29th of January.
Huh?
Can it be on the, if Your Lordship may allow,
22nd of January at best.
22nd, matter. Yes.
22nd of January is. Eh,
Third point, my lord, regarding recovery.
Oh, yeah.
Ms. So-and-so and counsel appearing for the petitioner has submitted that the learned senior counsel appearing in the matter.
So as per number 2 to 6, ma'am. 2
Huh?
to 5.
Sorry?
2 to 5.
That the learned senior counsel for the appearing for the petitioner is not in a position to appear today due to previous preoccupation, and the matter may be taken. Just a minute, don't interfere. And an accommodation may be made till 22nd of January. Full stop. Mr. Encidas appears for Encidas learned senior counsel assisted by Ms. So appears for the
M-
respondent
okay.
number
MDP.
MDP.
2 to 6, ma'am. 2
Two-
to 5.
and S. Agarwal appears for the respondent number 6 to 9. Full stop. List this matter again on the 22nd of January 2026.
I'm good. Published.
Item number 12.
May I tell?
Yes, yes.
First, you can take up the matter. In the morning, there was a mention on my part.
No,
Oh, my
because
God.
it is of 2020,
Yes,
Two.
two.
not without opening the file. We don't
Yes.
we don't allow a mention without opening the file. Yes. What is the matter
But to
about?
kindly see page 32,
Hmm.
next 9 of the petition.
Hmm.
There is a communication. Before that, there are several communication
Hmm.
by the authorities with the respondent number 3 and 4.
Hmm.
There was a fishery which was allotted in favor of the petitioner for period 2020 to 2027.
Hmm.
Some part of the fishery were, my lord, in possession of the some encroacher.
Hmm.
For that petitioner, though he has paid the, my lord, revenue,
Hmm.
he has approached the authority
Hmm.
for taking necessary action for removal of the encroacher. After consideration, after last communication is page 32.
Page?
32, annexon 9.
I'm seeing that. Yes, 32. Then.
Yes, there is a direction to the, my lord, circle officer and the officer in charge of the police station to take necessary action. Against that, my lord, they have not taken any action. Against that, we prefer this petition. So, my lord, present, they have not responded as of now.
No, their response has to be an everyday response. Today we have succeeded in stopping people. Again, tomorrow they will say we have succeeded. They can't respond every day.
Yes.
Mr. Gogoi.
Otherwise,
Uh,
there is an instruction in 2022 itself, Lordship.
Yes.
Some encouragers are there, Lordship,
Hmm.
and some steps also taken to remove them, Lordship.
Hmm.
This is the instruction.
Hmm.
Updated instruction, I will object to regard part.
Or
It's a 20 December 22 instruction, Lord.
The petition of, my lord, 22 perhaps September.
the circle officer who represents the circle officer.
We are repeating.
Huh?
We are repeating.
Oh, then we since there is already an order from the additional deputy commissioner Karimganj
What?
to the circle officer and the officer in charge
What?
to take necessary steps to vacate any illegal encroachment.
In the regard, my lord, may have to dispose of the matter there.
Is it not?
My lord, there was an order in the order dated, my lord, 26/9/2022. There is an observation, but they have not proceeded it. Because two authorities are necessary.
These encroachers have to move out before
I am paying revenue.
11th of January at least. They have to be removed. Otherwise, he'll be at a heavy loss. Huh? What do? We keep it in January for you to have instructions, or because there is already a direction from the additional deputy commissioner, whether it has been done or not. And a reminder may help them to do it. Heard Mr. Swansel and council appearing for the petitioner. Also heard Mr. K. Gogoi, additional senior government advocate appearing for all the respondents.
Okay, I am representing as number 2, 3, and 4.
2, 3, and 4. Huh? 2, 3, and 4. Oh, fishery department.
Fishery.
I think Mr. Sharma is not
Sharma-
doing well. Yes, let it be. We don't need the fishery department right now.
Yes. Today I can take.
Huh?
I can take.
For all the respondents, for all the respondents, full stop. The learned counsel for the petitioner has referred to the communication dated dated 2nd of September 2022, page 32, annexure 9, whereby the additional district commissioner Karimganj had directed the circle officer Badarpur and officer in charge Badarpur PS to take appropriate steps for handing over the possession of the fishery in issue to the lessee concerned and to vacate any illegal encroachment to avoid the loss of government revenue. Full stop. Notices were issued in this case on 26/9/2022, it was thereafter listed on 24/6/2024, and now it has been listed today. Full stop. Mr. K. Gogoi, learned counsel, appearing for the respondents, has sought for a short accommodation to have his instructions as to whether the directions of the additional district commissioner Karimganj had been carried out by the circle officer Badarpur and the officer in charge of the Badarpur PS. Full stop. He shall also obtain allowing the time sought for by Mr. K. Gogoi, this court also requires him to have instructions as to the present status of the functioning of the fishery. Full stop. List this matter again on the January, on the 6th of January. 7th of January 2026. Full stop. Yes.
Made it. Matter pertains to my non-payment of contractor's bill. Lordship takes on page 20. It's an admitted fact. They are admitted in fact. For the
Where have they admitted?
page
Sir?
20. Your Lord. It's not any deal. Otherwise, we are not a made party here.
Hmm.
He has some effect.
Do you have a copy of the writ petition with you?
I have a copy.
Can we have page 20?
First.
Reply to para 1. Liability of the contractor to the contractor is so much.
First.
Out of the total value of work is so much.
First.
Payment of so much has been made.
First.
Rest amount will be paid. So it is a matter of 377. Going by this letter saying that it is an admission on the part of the executive engineer. Appropriate authority to take on record this letter.
That-
And in terms of Tamsher
Lordship,
make the consideration and
First.
if entitled pay,
First.
we can do that.
First.
I'll record your presence for all the respondents.
say what prices
You are a additional senior government advocate.
I can.
Can you not represent the government? We will not impose it on you, but
No,
if you
sir.
can, then we
Finance
dispose-
is there. Explain about the finance.
finance.
He go
We'll
in
take it up after some time in the presence of Mr. B. Gogoi. We'll dispose it off. Otherwise, we are disposing.
May dispose. I will inform him.
Okay, done.
He over.
So this is disposed of. Record the presence. Learned counsel for the petitioner has drawn attention of this court to the communication dated 10/6/2020 issued by the Executive Engineer, Silchar Water Resources Division, Silchar, to impress that it is an admitted position that the that the petitioner is entitled to a sum of rupees 3,77,622 out of the total amount of bills submitted by him for works completed on directions of the respondent authorities. Full stop. We have also heard Mr. K. Gogoi, learned additional senior government advocate, and Mr. B. Gogoi, learned Standing Counsel, Finance Department. Full stop. Since no affidavit in opposition has been filed from the year 22 onwards, despite opportunities having been granted to the respondents, this case is disposed of by directing the respondent number 4 to take on record. Now, respondent number 2 and respondent number 4 to take on record the communication dated 10/6/2020 and such other documents as may be placed by the petitioner before the said authorities to cause an inquiry into the liability of the department to pay the petitioner the sum paid for, and in case the petitioner is found to be entitled to the said amount, following the law laid down in the respondent shall follow the law laid down in the case of Tamsher Ali versus State of Assam, reported in so-and-so. Full stop. The petitioner shall submit a certified copy of this order along with all supporting documents in regard to his claim before the respondent number 4 with a copy to the respondent number 2 within a period of 2 weeks from today. Full stop.
2, 4 and 6.
2, 4 and 6. Wherever I have said 2, you say 2, 4 and 6. Between the respondent number 2 to the respondent number 2, 4 and 6 within a period of 2 weeks from today. Full stop. The decision regarding the entitlement of the petitioner shall be taken within a period of 1 month thereafter with with intimation to the petitioner. Full stop. The payment to the petitioner shall be made in terms of the law laid down in Tamsher Ali. The petition disposed of, no costs.
Number 14.
In item number 14,
Yes, sir.
there is an order to obtain instruction whether the payment in respect of
Yes,
petitioner
madam.
number
Any instruction? Waited. Shall we facilitate it? Should the officers come with the instructions?
No, but-
They should come with the instruction.
But-
Okay, we'll call them. You really want the officers to come with the instructions? No. Heard Mr. J.M.A. Chaudhary, Learned Counsel appearing for the petitioner. Also heard Ms. So-and-so, Learned Counsel appearing for the PNRD department. Full stop. By the last order dated 26/11/2025, Mr. Dotto, the Learned Standing Counsel appearing on that day, was afforded accommodation to have instructions from the department as to why the petitioner's number 204, 210, 211 and 171 were not given the benefit of the PMAY-G schemes. Full stop. Today, Ms. So-and-so appearing for the respondents have submitted that she is awaiting instructions. List this matter again on 11th of December 2025. by which date the instructions shall be made available to the petitioner, to the learned counsel for the respondents. The instructions shall be made available to the learned counsel for the respondents, comma, failing which the concerned officials, that is the respondent number, the persons holding the post of respondent number 5, 6, and 7 shall remain. This video, Dulab Chara, is under you?
Right.
Huh?
Yes.
It is under you. And you can also inform the CEO and the secretary of the Gaon Panchayat.
Right.
Yes, of the Zilla Parishad and the Gaon Panchayat. Na?
Gaon Panchayat.
Yes. Shall remain personally present before this court, comma, a full stop. A copy of this order be supplied to Miss So-and-so Learned Counsel during the course of the day. And, for her doing the needful to forward this order to the concerned authorities.
Obliged.
But the matter pertains to conversion of category of land from agriculture to commercial. In fact, in 21, my premium was already paid. Thereafter, the matter got stuck because they said that this falls under eco-sensitive zone.
Okay.
Then we had already filed an affidavit showing that as per the notification of Amsang eco-sensitive zone, there are certain exempted activities. So only certain activities are prohibited in eco-sensitive zone. So as such, there is no bar for my lord to commercial activity. Only there are certain prohibited activities.
Okay.
That notification, my lord, the government wanted to bring on record, I think, on the last date. There is an order.
Earlier occasion, Mr. Vijay Talukdar Lordship, he appeared in this case and he was directed to file an affidavit. And today I have been told it is going to be filed today.
And that notification earlier is already part of the record. I have already filed that.
But
The
they want to-
instructions they have is already part of the record. Can we have it next week, my lord? Let that then also come on record.
Will it be filed today? We can have
Yes,
it.
yes, I have been told like that. It will be filed today.
Kindly ensure them.
Not my lord.
Heard
When is the
Mr.
next one?
Heard Mr. B. Pathak, Learned Counsel, appearing for the petitioner. Also heard Mr. H. Sharma, Learned Counsel, appearing for the respondent, comma, it has been submitted that an affidavit is being filed today on behalf of the respondents to bring on record certain vital documents
In
required
terms
for
of the order of
adjudication.
second September.
Adjudication, comma, the if that be so, comma, list this matter again on.
When is the next one?
Yes, sir. On 10th of December. 10th of December 2025, along with the affidavit proposed to be filed.
All right.
Number 16.
The inquiry report is, photo inquiry report is there.
Yes, what was the inquiry about? What was the grievance? That whether he died.
Yes.
Second page itself closely the summary of the inquiry. Second. First page is the.
I have seen that,
Second.
but this is done in the year 2025.
Lordship, as
Just
per
trying to find out.
after Lordship direction, that part.
Mhm.
Has indicated that it's a natural. No was closely responsible for that part of all.
Yes, sir. The entire course of event has been inquired into. From this inquiry report, it appears that yes, the husband of the petitioner had gone on a train with two other persons to detect hawkers, illegal hawkers. 2 or 4 of them were arrested, brought to the GRP, kept there. In the meantime, other hawkers started to raise a hue and cry. There was some protest. But during the time of the protest, even before the protest started, the husband of the petitioner started feeling unwell. He was required to go and take rest. Then all this protest and everything happened. That was settled. By that time, the petitioner's husband was feeling more unwell and he was shifted to the hospital, where unfortunately he was declared to be brought dead. So in that situation, it is true that he has expired on duty, but whether they would be entitled for death during a riot or this thing, that does not appear to be the case.
But scheme says anybody who dies in harness in performance of bona fide official duty.
Exactly. So that has to be reasonably understood. That has to be reasonably understood. Now, a situation where a person is sitting on a table doing his routine work, suffers a stroke, dies on the spot. This scheme does not come into play.
That's true. But
if someone is required to put extra stress into this work, if the person is made to stand on one leg and work the whole day through, then it is in the performance of his duties he had to give his.
now, my lord, may I suggest one thing, my lord? Let this inquiry report be part of the my lord, proceeding. We'll respond it, my lord. That will be the my lord, better.
This will prolong the litigation with the results far in sight for the petitioner. You will respond, then we will have it for argument, everything. That he died, even if you dispute this inquiry report, it will be a dispute which this court cannot go into. Is it not? So that would require some amount of evidence to be led to show that he had participated in that protest part. He had tried to stop it and therefore he met his demise. That will require some amount of evidence to be led by the petitioner, the person who informed her, the persons who were there at the office at that particular point of time and all that. So whether the writ court would be the appropriate court or not, given this inquiry report, you may have your instructions on that, or you may advise your client on that.
In that case, my lord, yes, fine, my lord. The inquiry report, if it is my lord, furnished to-
They will furnish it to the
Yes.
petitioner.
that
The moment
that can be.
this is a court of inquiry that relates to the death of the husband of the petitioner. There is no harm in giving her a copy. So at least she would know who were the witnesses whose statements were recorded and whose statements she now needs to depend upon to.
By Monday, I will provide them. Lord. Today, I will xerox it and by Monday provide.
So do we dispose it of today or we should keep it for some other day? Your suggestion.
Let it be after a week, my lord. In the meantime, my lord, we may be furnished the my lord copy.
Okay.
We'll
Take it down. Take down. Heard Mr. M.U. Mondal, Learned Counsel, appearing for the petitioner. Also heard Mr. K. Gogoi, Learned Counsel, appearing for the NF Railways. Good stuff. By the last order of this court on 29/10/2025, Mr. K. Gogoi, Learned Standing Counsel, was permitted to place the report of the court of inquiry conducted into the circumstances which led to the demise of the husband of the petitioner. Full stop. Today, Mr. Gogoi has placed the report before this court. Full stop. from a perusal of the aforesaid report, it appears that though the husband of the petitioner was present during the time of arrest of some illegal hawkers and also was present in his duty at the time when the hawkers had protested, the demise of the husband of the petitioner was not directly linked to any activities during the performance of his official duties. Full stop. Mr. M.U. Mondal, Learned Counsel, has requested for a copy of the court of inquiry to be supplied to the petitioner so that he may have appropriate instructions in the matter. Full stop. List this matter again in the January Pokso, week to deduction into 19 episode on 20th of January 2026, by which time Mr. K. Gogoi has undertaken to supply a copy of the inquiry report to the Learned Counsel for the petitioner, and the Learned Counsel for the petitioner may have his instructions on the matter. So, but otherwise, it will only prolong the litigation here. Once the death is asserted by them not to be on during discharge of duties, we will not be going into that.
Let us have.
So once you can have evidence led that he was tired when he came down, he was not properly attended to when he was, that will go before the court where the evidence could be led.
Right.
The court will come to its own conclusion. Can we do it here? We cannot do that. And the court of inquiry, we have seen all the persons who were on duty at that point of time, their statements have been recorded, particular time has been given, where before the protest began, he retired to take rest because he was not feeling well. And that is part of his duty. To arrest someone is his duty.
We'll have the instruction from
Have
our
your
client.
instructions. Have your instructions. But this writ is not taking you anywhere, is our tentative prima facie view. Yes.
Marriage.
Yes, sir.
I am seeking time for filing affidavit in reply.
Covered case, my lord, it relates to my lord election of pharmacy council.
This is
The appellate provision, similar case was disposed of, referring the case to the appellate authority. Election.
according to my
That day my
it is not
counsel
covered.
was not present.
How
that's
does it
why-
differ? Tell us.
That is not covered.
How does it differ? Tell us.
We have challenged,
Because they have no locus, my lord.
we have challenged the notification, madam. If you have a subsequent notification, madam, I am going to challenge that. That is, madam,
Sorry?
subsequent notification is, madam, 8/9/2025. Again, madam, they have, madam, designated one inside register, madam. That is illegal. We have challenged the, madam, we have challenged the designation of insert register. Madam, they know after
Oh,
what
it is not about even a notification. For the aforesaid, it is clear
madam,
that the
subsequent, madam, subsequently,
that
madam.
cancellation of the election and
Sir.
holding of fresh election can very well be dealt effectively under Rule 25 of the Rules of 1959, read with Section 24 of the Act.
That is, my lord, they have not made the 6 persons who were elected as member of the council.
Any other person in presence of Mr. Madam, Patu
How
Sharma,
can this
I am not,
be
madam, not on record, madam.
Huh?
I am not record, madam.
Then none appears for the petitioner on call. There seems to be
No.
nowhere. Then we go by that.
Madam, on behalf of Madam Justice Sharma, I am appealing for seeking time.
That was the first prayer to be made.
Madam, that, madam, any other person in presence of, any, next week, madam,
What is the prayer in the writ petition?
Necessary, I will file a petition affidavit bringing this fact.
Which this order?
Yeah. it's
This
not
order is
necessary.
this order is a part of the court record.
Okay.
But your lordship fix on next week, my lord, and
Here, a notification is also under challenge. In that
Notification
case
is
also it
also-
was under challenge.
After this matter, the authorities has considered their representation and
But-
passed an order saying that there is nothing wrong in the.
dear my lord, notification is challenged.
Notification dated 1/1/24.
And even subsequent, my lord,
1/1/20.
8/9/2025, there's another notification.
Election.
They have issued, my lord.
My lord, please.
Now, my lord, we are going to challenge that notification. too.
Para 5.
Seen that.
8/9/20
Notification.
8/9/25, my lord, they have
He's
This
arguing,
is not under-
let it
not-
be hard then.
next week, but I am seeking time, my lord, only next week.
Whether he says that he's taking time or he should argue that. Let it be hard, we have.
And that is our exact intention. If someone wants a time, we are allowing it very liberally. But if someone is trying to say that this way, that way, we will not do the matter today, we don't want to do that. We want frankness. We deal frankly in this court. We speak our mind when the arguments are going on.
No, but I am not arguing.
This
my
way,
lord.
that way will not help.
At the first statement, I am taking time.
Any stay order operating?
Nothing. Let it be
in
in January, my lord.
January? Mr. Swenson, council appears for the petitioners.
Document record is covered by this.
Yes. Mr. Swenson, senior counsel appears assisted by? You are assisted by? Mr. Swenson. Mr. Swenson appears for the Department of Health. The learned counsel for the respondents have submitted that these matters are covered by the decision of this court in WPC 1563 of 2024. And what about this order, this 6974 of 2023? Association of Advanced Pharmacy Practitioners, you have any idea on?
156.
Huh?
156.
There is 1563 and there is another order available here.
We have given that now. So, 156. 156 out of what letting the election. After the election, give it.
Okay.
Order dated
1563 of
10/6/25.
2024. Stop. The
That's
learned
it.
counsel appearing for the petitioner has disputed the same and has prayed that the matter may be taken up.
Because there's
After
not,
2
they have
weeks.
no local.
Huh?
Because they have not
Ah.
made the
The
elected
learned senior counsel appearing for the respondent number
7.
7 has submitted or has disputed the locus of the petitioners to maintain this litigation. Stop.
They have not contested the election.
Since the petitioner has not contested the election. Stop.
And
And
this petition is not maintainable because the elected members have not been made.
moreover, the elected members have not been made party respondents in this litigation. Full stop. The learned counsel for the petitioner seeks an accommodation for 2 weeks to be allowed to address his arguments. Full stop. List this matter again in the 4th week of January 2026 on a date to be fixed by the registry. Full stop. The matter is of 2024 and relates to elections to the Pharmacy Council of India. Full stop. Parties are requested to be prepared for final arguments. Yes.
Diploma.
It is over 90.
Yes. Last occasion it was paucity of time. Now we have plenty of time. What was the prayer?
Payment of bill for work done.
Yeah, for bill.
I will kindly paste the instruction of third paragraph, Lordship, during the verification. It start from during the verification.
Not submitted to work order and the quantum of collection of biomedical certificate or transmission. This
Lordship,
petition,
communication also given, Lordship. My Lord, may kindly pair last 2 pages of the instruction. This to the petitioner also. One is vernacular and another one is.
heard Mr. So-and-so, learned counsel appearing for the petitioner, also heard Mr. K. Gogoi, learned additional senior government advocate appearing for the respondent. Full stop. This matter relates to the prayer for directions for payment of bills raised by the petitioner for services provided as per memorandum of understanding dated 27/5/2020 entered into for disposal of biomedical waste generated in the quarantine centers and treatment centers during COVID-19 period. Full stop. Mr. K. Gogoi, learned additional senior government advocate, has produced the instructions addressed to him by the additional district commissioner, Sibsagar, which indicates that during verification of the bills of the petitioner, it was found that the writ petitioner had not submitted the work order and the quantum of collection of biomedical waste certified by the authorized persons at the collection points. Full stop. In this connection, letters were sent to the writ petitioner via issue number. You can take this from your issue number, capital SVRR oblique COVID-19 oblique 29 oblique 2020 dated 28/12/2023 to submit the supporting records against the amount claimed. Full stop. It is reflected in the instructions that the writ petitioner has not submitted the aforesaid records to the authority till date. The bills are now in the verification stage and can be cleared post verification subject to fulfillment of the aforesaid documents and other financial guidelines. Full stop. Faced with this situation, faced with this instruction, the learned counsel for the petitioner has sought for an accommodation of 2 weeks.
Lordship may allow me to approach the authority with the
We'll close the writ petition.
with liberty if there is any further.
Faced with this situation, the learned counsel for the petitioner has fairly submitted that this writ petition may be disposed of, giving the liberty to the petitioner to submit all requisite documents along with his bills again to the appropriate authority. Full stop. Mr. K. Gogoi does not, learned counsel appearing for the respondents does not object to such prayer. Full stop. Accordingly, this writ petition is disposed of, giving the liberty to the petitioner to resubmit his bills along with all requisite documents to the appropriate authority, who on receipt of such bills shall cause an expeditious verification and shall inform the petitioner the deficiencies, if any, so that the petitioner may correct them. Full stop. Upon verification, the respondents shall thereafter take appropriate action as required within a period of 45 days thereafter. Full stop. Writ petition disposed of, no costs. Yes?
Kept as a part of the record.
The instructions produced by Mr. K. Gogoi is kept as a part of record and marked as Annexure X. You can give us a copy, in fact, a copy of this. This is the original signatures.
Yep.
You will get the copy.
Yeah.
Thank you.
Pleasure.
I think 20.
Yeah, please. Instruction was called for non-consideration of the petitioner's claim for settlement of land 9 measuring 9 lessons covered by tax number 573 of Revenue Place, Julia Pillar.
My lord, I'm appearing for sericulture. My lord, I think they did not get any inspector. I have to bring the inspector. And
He
yes.
doubts the capability of your client.
No, my lord.
He saying something else. Page number 55 of the date petition.
Ha.
Here taking allotment. After
Yes.
de-reservation. We have de-reserved the land,
Hmm.
but there is a, their department, they have a,
Actually, the land is a
Seed-
farm of
seed.
agriculture, seed farm.
so they have to give NOC.
We have to give NOC.
Then we can give it to him.
So I will get the instruction, my lord. What is to
Heard Mr. G.G. Gogoi Leonard Council appearing for the petitioner. The reservation has been done.
Yes.
Now the NOC has to come from them. We'll wait for some time. We'll wait for some time. Let them say whether they want to give an NOC or not.
But already, the Honorable Governor also passed the order.
Wait.
Lordship, an extra A space 49.
Oh, then how can you withhold the NOC?
Space 49, Lordship.
Given it. Thereafter, they have deposit premium.
Have you?
No, Lordship, till now they have not the order for deposit premium.
You have not told him how much is the premium.
Yep.
Now, after this letter of page 49,
59, there is no requirement of NOC.
NOC is never a question here.
But there is no.
There is
No, Lordship, I
Let
am
him, let him pay the premium. Then Mr. Dhar will file a writ petition against the forceful eviction without notice. There is a difficulty. He is in possession. His assertion. Governor has ordered it. We are running around for a NOC, which is now not required. Mr. Sharma, are you appealing for the DC?
Yes.
Then this page 49. Fix the premium, let him.
May I please this one, Lord, before.
Please.
So by keeping that as a part of the record, Lordship may dispose of this matter, right? That is the same.
Huh?
That is why Lordship, my learned friend wants to.
Because of this.
At least this is 3 paragraphs saying yes or no.
Yes, sir. Yes, it's true.
Otherwise, usually from top to bottom, it is.
No comment. So,
So we dispose it of directing the district commissioner to let him know the premium.
and if they are unable to, they must inform him the reason behind.
After
Otherwise, Lordship,
the governor has
Lord-
given the no
Lord-
consent,
Lord,
we will
that
record that
consent- I've seen Lord.
there is nothing in the from the year 2024.
Lord,
Nothing has been brought on record to show that there is any legal impediment in
Lord.
proceeding with the allotment to him.
Lord,
The only impediment that now appears to this court is the premium
Lord.
to be informed to him, which he is required to pay.
That is
So
all.
the premium will be informed to him within a period of 1 month or more.
It will be within a period of 6 months, Lordship. Most
What
probably
is the
certain-
premium that he has, that you have?
Yes,
been-
yes.
He will make the payment of the premium and the entire allotment process along with correction of records, revenue records will be done within a period of 6 months
Lord.
from today. Huh? You can tell us.
Handing,
Huh? Anti-government?
handing over.
He says he is in possession.
It
It is in his possession. And if he requires possession after that, there's something near that Digholi Pukuri. He can go there and take the possession. He need not come on this side of the Pukuri. Yes, heard Mr. G.G. Gogoi Leonard Council appearing for the petitioner. Also heard Mr. A. Bhattacharya Leonard Council appearing for the respondent number 1. Mr. H. Sharma Leonard Council appearing for the respondent number
4, 5, 6, 7.
Huh? Mr. Dhar for respondent number 2 and 3. And why do you leave respondent number 8 in the lurch? Let him also be represented.
Officer in charge of agriculture.
And you have to ask your typist to do what?
for correction of
Sericulture and respondent number 3.
yes, sir.
Station at respondent number 8. Otherwise, they will say that this is not addressed to me. Full stop. This writ petition had been initiated in the year 2024 and till date. There are neither any instructions provided nor any affidavit filed by the respondents, by the official respondents. Full stop. The learned counsel for the petitioner, Mr. G.G. Gogoi, has drawn the attention of this court to Annexure H, page 49 of the writ petition, to state that the governor of Assam was pleased to agree with the de-reservation proposal and to settle the land measuring 9 lessas covered by DAG number 573 of village Dulia, Perabhari under Dhukwakhana Moja in favor of the petitioner, after, realizing premium assessed on up-to-date valuation. Full stop. This was done in the year 2014. The learned counsel for the petitioner has submitted that by the letter dated 22nd of May 2020, the Joint Secretary to the Government of Assam Revenue and Disaster Management Department had requested the Deputy Commissioner Lakhimpur to request him to intimate, had issued, to intimate if the administrative department has provided NOC to the local authority for de-reservation of the 9 lessas of Muga seed farm covered by DAG number 573 of village Dulia, Perabhari Moza, Dhukwakhana, and if so, to submit copy of the same to this department for confirming settlement order in favor of Sri Debakumar Phukon, the petitioner here in full stop. The request of the Joint Secretary by the letter dated 22nd of May 2020 appears to this court to be unreasonable, inasmuch as the Governor of Assam, by the communication dated 19th of March 2014, had already communicated the pleasure to agree with the de-reservation proposal and to settle the land measuring so-and-so in favor of the petitioner. Full stop. Nothing has been brought on, as recorded herein before, nothing has been brought on record by the respondents to dispute the claim of the petitioner. Full stop. In fact, the learned counsel for the Mr. A. Sharma, learned counsel appearing for the Co-District Commissioner Dhukwakhana, has placed before this court an instruction which, apart from the addresses, contains no material information save and except the words inverted commas no comment for most of the paragraphs, and yes, it is true with regard to some of the paragraphs. Full stop. Situated thus, this court has no hesitation to hold that the petitioner is entitled to be afforded the settlement of land. A description to Dibaha measuring so and so covered by DAG number so and so agote jitu disilu, in his favor on payment of premium as required under law. Full stop. In view of the above, this writ petition is disposed of by directing the respondent number 4, the district commissioner, the respondent number 4, to intimate the petitioner the premium that he is required to pay for having the land settled in his favor, within a period of 1 month from the date of receipt of a certified copy of this order. Full stop. The petitioner shall thereafter No, if the petitioner thereafter pays the premium within the time frame allotted in law, comma, the order settling the land in favor of the petitioner shall be issued within a period of one month from the date of payment of such premium, full stop. The other formalities requiring the other formalities, comma, including the correction of the land records in the name of the petitioner shall be completed within a period of 6 months from the date of settlement of the land in favor of the petitioner, full stop. Writ petition is disposed of. Oh, you write one sentence before that. In case there is any legal impediment in allotting the, in settling the land in favor of the petitioner, comma, the same shall be informed to him within a period of 30 days from the date of receipt of this, of a certified copy of this order, full stop. Writ petition disposed of. No costs. Copy of the instructions provided by Mr. H. Sharma is kept on record, marked as annexure, marked as X, as flag X.
Item 21.
What did you speak to the Speak to the
Please.
Yes, sir.
The subject matter involves the challenge to the notification 9 of 23 and 56 of 23. But if the same subject is pending before our Honorable Division Bench as well as Honorable Apex Court, it's pending, man.
It is heard Mr. So-and-so and counsel for the petitioner also heard Mr. So-and-so. You also appear? All the attendance, huh? Right. Huh? 4 and 5.
And for 2 and 3.
2 and 3, huh?
Dot.
Full stop. It has been submitted in consonance that the subject matter of this writ petition is pending before the division bench of this court in appeal and also before the apex court
SLP civil
in special writ petitions preferred by
the State Commissioner Telangana.
Anna?
In SLP civil number 4 to 4.
In such view of the matters, the counsel for the petitioners pray that the have submitted that the matter may be taken up after disposal by the after disposal of the issue by the honorable by the apex court, full stop. Release this matter after 6 weeks. Release this matter after 6 weeks. Full stop. 6 weeks on a date to be fixed by registry, full stop. The parties would be at liberty to make a mention if the issue is disposed of by the apex court prior to that date.
Item 3.
Huh? The last order of this court passed on 1/12/2025 recorded as follows. A last paragraph. Huh? Today, none has appeared for the party on second call also, full stop. In view of the above, and since the term of the board has already expired, comma, this writ petition is closed as, what do you say, non-prosecution, for non-prosecution.
What?
Non-prosecution? No, I recorded that. Since the board has already expired, non-prosecution. Huh?
Okay.
But since the board has expired and no live cause remains to be adjudicated, full comma. Huh? This case is closed for non-prosecution.
Item 23.
Yes, the matter has become infectious.
Huh?
Matter has become infectious.
This matter has become infructuous. It is submitted by the learned counsel appearing for the petitioner that the matter has become infructuous and does not require further adjudication. Full stop. Accordingly, this writ petition is closed as infractuous.
Fair play. Well, in this case, my lord, the issue is lordship whether government can, my lord, take my lord, land of private, my lord, citizen lordship without any process, my lord, in the name of my lord, giving job to the my lord, patta holder lord.
Oh, yes.
My lord,
I'll file my
Without
affidavit
job,
to-
they can take the land. There is no problem.
without job, my lord, but
They
in
cannot
such a
take,
case,
they
lordship,
cannot take the land without giving you compensation. The question of job does not arise.
nothing is there. No compensation was my
You pay
given.
for compensation. Raise the question of a job.
Well, in such a case, similar case, the honorable court, my lord, directed to pay compensation.
We'll direct for payment of
Yes.
compensation, not for job.
I also filed, my lord, submitted a representation for
Where
that.
is that?
Either return the land or the pay compensation. Yes,
Alternate prayer we are rejecting straight away.
my lord, return.
Land for job that we are rejecting.
My lord, distance, my lord, as is over, my lord. We are not interested, we have not. elected.
Yes,
I'll file my affidavit.
saying what, that you are not in occupation. That you
No,
cannot
Lord,
say.
It is somewhat different. I'll file my,
By when?
after 3 weeks, after
Wait.
vacation.
24. Oh, yes, yes. Yes.
Lordship comes to below. As per order dated 26/10/86, the assistant settlement officer in the Stita land measuring 1 biga under Dark 30 is situated in the name of Joint Director Protect. It's way back in 86. This order has not been challenged till now. Moreover, if your lordship comes to little bit up, 1 biga 3 kotha 2 lesa has been mutated in the name of Sahab Ali, my lord. And his salary shows only 1 big. 3 kotha where comes. A dark may consist of, my lord, 1,000 bigas. So he's saying he has given one quota of land. Prima facie, I don't think so any case has been made out. Thus is my submission. So lordship wants, I can fight.
My lord, till now I am paying my lord revenues.
On your land, there is no dispute.
My lord, in the
Land
entire
revenue does not give title. I can pay land revenue to the Daspil also, my.
Ah.
It does not come under.
Now report, my lord, Kali, a certificate was issued by the, my lord, medical officer lordship.
Sir,
That is page
Mr. Ahmed,
38.
you would be on a better footing to argue once their stand comes on record
Yes,
by an
sir.
affidavit.
Lordship, I will
Huh?
get opportunity to reply.
Is it not? Yes. Ms. Swensol and her counsel paying for the respondent number Swensol has prayed for an accommodation to be allowed to file the affidavit in response to the allegations leveled in the writ petition. Full stop.
It should be last chance, Lord.
Why?
My lord, for last, my lord, it was filed in
24,
2000.
my lord.
Case was, my lord, last order kindly see thereafter nothing was done, my lord.
That is
You
what
know,
is hurting us. Nothing
not
was
taking
done on
over.
your behalf also.
Lordship.
Nothing was done on your behalf also. Can you
For-
show us what you have done
For
to have the
listing the
matter
case, Lord.
yes, to pursue the matter? What have you done? Show us.
I
Any
will go on
mention
here.
memo, any application to the registry, anything.
One affidavit is not filed, Lordship.
So, you should have pressed for the doctrine of non-traverse.
Lordship.
Eh?
But
Sleeping foxes do not catch ducks. Translate in Assamese.
yes, Lordship, it may be so far as my lord.
Yes,
are
Ms.
the-
So-and-so has prayed for an accommodation to be allowed to file the response to the writ petition. Full stop. The matter is of the year 2024 and notices were issued in the month of June 2024. Full stop.
3620.
Huh?
3620.
36.
36.
36. Okay, 36. That is what we said, June 2024.
Okay.
Full stop. The matter relates to the payment, to the prayer for payment of compensation for land allegedly occupied by the government, by the respondent authorities.
In lieu of a job.
In lieu of?
Job.
No.
They're
He's praying for adequate compensation,
or job.
return of land or job. A job we are not even going. Okay, for adequate compensation with regard to the land being illegally occupied by the respondent authorities, full stop. Let this matter be listed again in the first week of February on a date to be fixed by the registry, by which time the respondents shall ensure filing their response, full stop. The petitioners would also be at liberty to file their response to the affidavit in opposition before the next date of listing. 25.
And please, Your Lordship, I'm appearing for Mr. Vijay Mukherjee. He is out of state. So kindly adjourn the matter for the.
What about your
Only
response?
it's a transfer subject. BTC will have to
Yes.
accept it.
I may pay for it, well, Lordship. Info matter has
Ah.
come up only for the second time, Your Lordship, and
Ah.
since then it has been a change in process.
How many times it is required to come up before you can come up
No,
with an affidavit? We'll have
definitely,
it listed
Lordship.
every week.
We don't have the brief also, Lordship.
Ah.
Like paying for the complete.
Mr. So-and-so and council appearing for the BTC. Respondent authorities in the BTC has submitted that there has been a change in the councils and they are not in receipt of a copy of the writ petition, full stop. Learned counsel for the petitioner has submitted that the counsel for the petitioner is also out of station and may be accommodated for today, full stop. In view of the above, list the matter again in the second week of February 2026. Full stop. The learned counsel appearing, your name, Ms. So-and-so?
Yes, but
Ms. So-and-so, learned counsel appearing for the petitioners has undertaken to inform the counsel for the petitioners to supply a copy of the writ petition, to supply requisite numbers of copies to the counsel appearing for the BTC authorities within a period of 10 days from today. Full stop. The respondent authorities would be at liberty to file their response before the next date of listing.
much obliged.
You ensure that the copies are supplied.
Item 27.
Number 27, my lord, I beg to appear for the respondent numbers 2, 3, and 4.
Yes.
So on the last occasion, my lord, your lordship had directed the petitioner to serve upon me, my lord, the additional affidavit, supplementary affidavit filed by. Now, my lord, while my lord, my client has received it just a few days back, I have received it just yesterday. Now, my lord, your lordships just a few minutes ago said that my lord, we have to be forthwith before your lordships. So, my lord, one issue is that I have to take certain instructions basis the supplementary affidavit. My lord, I'll indicate what the supplementary affidavit says. It talks about certain amounts which the
You have
petitioner-
received the supplementary affidavit yesterday and you would like some time to
my
have
lord,
your instructions on the same.
instructions and my lord, if required, file an opposition to this.
Okay. He received it yesterday. He'll have to talk. Heard Dr. B.N. Gogoi, Learned counsel appearing on behalf of the petitioner. Also heard Mr. Kejriwal, who appears for Mr. K. Kejriwal, who appears for the respondent number 2, 3, and 4. Full stop. Mr.
Yes.
Kejriwal has submitted that he has received a copy of the supplementary affidavit filed by the petitioner yesterday only, and therefore some accommodation may be afforded so that he can have his instructions and file a reply to the same if necessary. Full stop. Accordingly, list this matter in the second week of February on a date to be fixed by the.
I beg to apologize.
Uh-huh.
Urgency is there because
What is the urgency?
my money has been wasted in
From
this case.
7/11/2025, you are supplying a copy yesterday.
Oh,
Had you supplied it on 8?
yes, I had
it would have
applied
been so
earlier
happy,
before.
happy.
He has been the local
Well, I have
advocate of
received.
here in this
Oh.
department. This case I have already applied on the next
Then,
day, 7/11
The problem is this: December, most of it is,
January.
from now on, most of it is gone.
I beg to mention.
January, how many working days do we have to fix
Lordship,
matter?
what has happened? He had already paid me during the pendency of his petition.
Huh. So,
So my humble submission is that, so whatever the amount is there, I'm waiting for his reply. No issue. So my humble submission is that it's a pandemic business or pandemic.
okay, let this matter be again listed in the third week of January on a date to be fixed by the registry. Allowing Mr. Kejriwal to have his instructions, full stop, the matter relates to a claim for payment of bills.
Yes.
And therefore, the learned councils are requested to be prepared on the next day with their submissions so that the matter can be taken up for disposal.
My
On
lord,
the next
my-
week, we'll try for a disposal. Please do not go for any more time.
Grateful. No, my lord. We shall not, my lord. I'm only, my lord, saying, my lord, that we have a preliminary objection to the maintainability that, my lord, we'll take from the.
On that day, we'll finish it off.
Yes.
Mr.
Great.
Kejriwal has submitted that the issue of maintainability may also be taken up on the next date of listing.
Thoughts.
Great. Great.
Develop.
Oh. Yes, sir.
May I please, Your Lordship, move? This is the eviction matter, my lord.
Mm.
There was an order of this honorable court, my lord,
Mm.
dated, my lord, 18/9/24, my lord. But unfortunately, we have already been evicted now, my lord. On 24th of September, my lord, we have been evicted, my lord. Thereafter, my lord,
Pendency of this case.
my lord,
During pendency of the case.
during pendency of the case, my lord.
Oh.
And my lord, what they have done, my lord, there has been a clear demarcation, forest land and revenue land, my lord. But they have, my lord, evicted the people of the revenue also.
So why can't they evict you? What is wrong in their
No, no,
eviction?
no. There is no wrong, my lord. But if it is a revenue land, my lord, then, my lord, at least there is some procedure, my lord.
Yes. What is the procedure?
Procedure, my lord. Notice, my lord, individual notice, my lord, at least. One, my lord, overall notice has been, my lord, hanged with the tree, my lord. And then the villagers have been evicted. There is electrification, PWD road, my lord. Water supply, then 2 LP schools, 2 Anganwadi centers, my lord. Normally, my lord, these institutions are not, my lord, allotted in the forest land, my lord. And KL and AF, my lord, all KL have been, my lord, termed as AF, Assam Forest, my lord. Kindly see, I
Who
have
appears for the forest? Huh? Necessary party. They are a necessary party. It is necessary for them to appear. Let us-
affidavit is required. I have filed IA also.
Huh?
I have filed on IA also.
F2, my lord. I did.
2.
Well,
Inform the council for the forest department if you meet him on the way. Hmm.
The brief was taken from our throat.
Hmm?
The brief was taken from our throat. I'm appearing on behalf of Mr. P.P. Dutt.
Of Mr. P.P. Datta.
Yes.
How? By what means it was taken away?
He was engaged in this matter.
Huh.
But he informed me that brief was taken from.
Wakalatnama Khan sir. আছেনে? ইয়াৰ লগতে বান্ধি থয় নেকি? মইতো পোৱা নাই ইয়াতে। ইয়াত নাই, সেইখনত আছে। আছে? নাই। বিনা অকলতনামা কেনেকে চলি আছে? So what to do today? Brief has been forcefully taken away from them. What to do? Hmm? বিনা
Right.
You are appearing for Mr. P.P. Dutta. Ms. Swenson and counsel appearing for Mr. P.P. Dutta has submitted that the brief has been withdrawn from them by the petitioner. Full stop. List this matter again after 6 weeks. Is there any interim?
Interim is not there, but demolition order is there.
But interim is not there.
Yep.
Oh, no steps be taken. There is an interim order.
Got
2012-2024. There is an order. We'll
Okay.
give an opportunity for them to appear, to the petitioner to appear.
I think there's a procedure, Lordship, if the brief has been taken away.
And we'll record it
Because
that the. So we'll record that it has been stated by them that the brief has been withdrawn.
I think
We'll give them time to file
my
appropriate.
friend should file an affidavit.
We'll give them the time to file the appropriate application and also to the petitioner to make alternate arrangements in the meantime. And we'll list it in the month of after 6 weeks
Got
on a date to be fixed by the registry. It has been submitted by Mr.
Otherwise,
Benson.
Lordship, in this case, Lordship, initially a plot of land was mutated in the name of the petitioner. Subsequently, the NOK was cancelled. Thereafter, the mutation was also cancelled. As he is no longer the owner of the property, Lordship, the building permission issued by the authority, that was.
Okay.
So that is the.
But since it was granted when he was the owner.
Yeah.
That permission, how can that be revoked?
No, at that.
We'll decide it when he wants to argue the matter, then we'll decide it.
Yeah.
Why should we rake our heads now?
Otherwise, Lordship, the opportunity given, Lord. Notice was issued, he appeared. After hearing the petitioner, Lordship, petition was taken. So because, Lord.
We don't want to pass any orders when he's not under representation. That is the only issue. Yes, on the next. List this matter again. That the brief has been withdrawn to likhi leto. List this matter again after 6 weeks, by which time the engaged, by which time the allowing Mr. P.P. Dutta and other persons engaged in the wakalatnama to move appropriate application for withdrawal of the wakalatnama and also to allow the writ petitioner to ensure appearance on his behalf before this court. Full stop. Interim orders passed earlier shall continue. Yes.
Okay.
Mr. P. Nayak, Learned Additional Advocate General, appears for the respondents. Yes, madam.
But we have not received extra copies. Extra copies. We have for respond number 2, 4 and. Let's say madam will pass over for time. The can discount it.
You are appearing for respondent 2?
2, 4 and 5.
Ms. Swenson and counsel appearing for the respondent number 2, 4 and 5 has submitted that they are yet to receive the requisite numbers of extra copies of this petition. Full stop. Ms. Swenson appearing on behalf of the petitioner has assured that extra copies will be served within 3 working days on Ms. Swenson. Full stop. List this matter again after 4 weeks on a date to be fixed by the registry, by which time the respondents shall file their response to the writ petition. If you don't give copies on the next date, tie the file, send it back. Yes.
31 and 32.
Yeah. Yes, all copies exchanged.
Exchange, but only the respondent number 7 has given a copy. We'll type, and Mr. D Das is also not there. Well, subject to your lordship's convenience, if it is on 17th of this month, Wednesday, subject to your or first week of January, anything. We have taken charge, but they have also want to express their urgency. Either 17th or first week.
My lord, there will be some difficulty on the part of Mr. Jain. He may be out of the
Then immediately on reopening of the January 1st week, immediate. I'm all the way up to 9 times.
We are ready. On behalf of
There
Shine
is
Club.
one affidavit where we think we have to file it, that where HRS Chaudhary has appeared. That's one number 7. So, my lord, the government is there, Deputy Commissioner, they will come with all the records and all. The last will take it up for final disposal in the first week of February. At the admission stage. First week, my lord.
Was deposited.
Yeah.
Ah. Huh. Of the district. Oh, Kamrup Metro. We will say that. So they did not receive. Huh? And the other one? Other one you speak.
They have taken, every time they are taking time, my lord, and they are usurping the office. On 2 occasions, they have already taken time. This will be the 3rd.
No,
Not every case is important.
Either 17 or Manal immediately after reopening of the.
No reopening. No, my lord, their possible kindly is a very small matter. Sir. They are
One person is
guilty of, my lord, disqualification. That's all. Simple case. Out and out, there is a case of disqualification.
If they say they do not rely on the affidavit of respondent number 7, then it's a different. But they have, since they have said against us, we have to fight it. Because that
He has received a copy of the
only on the as per your
affidavit in
lordship
opposition by the respondent number 7.
They have filed it long back, but they have not given us the copy. It was only in last order of the court, they have deposited the cost and punished us. Just day before yesterday.
Day before
Lord,
yesterday.
if it is not inconvenient, can it be taken up on Tuesday?
No, Tuesday I'm not there, Wednesday I'm
Then
there.
let it be Monday.
No, Monday, Tuesday, no, Wednesday.
Wednesday is it convenient?
I think Friday all.
Nothing. Oh, please.
Little
Like a court.
import. So,
Let it be on Monday, my lord.
Monday is there. I think Friday all.
Mask to come on. Let it be on 15.
15, my lord, I'm not there.
No, that we cannot agree.
17th.
No,
17th. That's why I've said 17th.
No. Let it be on 15. Lord,
No.
end of the day, some adjustment everybody has to do.
My lord,
My learned meeting saying Monday is not available. Tuesday also may agree.
my lord, if-
How can I agree to 15?
my lord,
Lord?
say,
Let
if-
it be on
yeah,
15.
my
No.
lord, if my learned friend doesn't want to accompany me, let him argue.
Ah.
Whatever we have, we'll submit. If
No,
they
Lord,
will say, if he
end
is
of
not
the
with-
day,
he is my senior.
all
I can
represent.
make it.
No, I'm not saying that.
Yeah.
Please try to understand one thing. We all represented some interest. As you are holding the trust of somebody, I'm also holding. Therefore, I'm also answerable.
10
That's
or
why I'm saying.
10 or 17, anything.
No, let it be on 15.
No, 15, I am not there. Your
Then you have to make some alternative arrangement.
No, I can always pray to the court.
Huh?
Let
Let it be 15, Miller.
Because either 10, 17, or my lord, your lordship may
Then Lordship will
12.
stay. Then Miller, let the matter come up. Lordship will consider the interim prayer today. I'll satisfy Lordship in 5 minutes.
12 here.
Hmm?
No.
12 I can be there.
12 is
No, Miller.
12 is Friday.
Mala, I'm praying for interim, Miller. I'll
Let-
place for interim.
let my learned friend is
12
not-
Friday. 12 Friday is this week. In the coming
week.
week. Before 15th, he's praying for it.
12.
Before 15th, on 12th.
12.
Will you be available on 12th?
I'm not there, Miller. Actually, there's a marriage in my family.
Okay.
That's why I said 15, Miller.
10,
Huh?
10. I'm preponing it on to 10. Only 8 and 9 I am in info.
All right,
And
let
if
it
you
come up on 10.
10th.
Yes, will not seek adjournment.
10th is
Yes.
okay. 10th. Okay. The affidavits
Affidavit file करा copy क्यों नहीं?
as required to be exchanged by the order dated 25/11/2025 has been exchanged. Full stop. The learned counsel appearing for the respondent number 7 has submitted that the costs in favor of the district legal aid services could not be deposited since the order failed to reflect the district in which the said cost was required to be deposited. Full stop. It is hereby clarified that the respondent number 7 shall deposit the cost of rupees 2,500 to the district legal aid services, Kamrup Metro Authority, district legal aid services authority, district legal services authority, Kamrup Metro
At what?
at Guwahati. Full stop. Since Mr. B.D. Kaur has submitted that the affidavits have been served to him only day before yesterday and has prayed for an accommodation, Mr. Kane Chaudhary, learned senior advocate, has objected to the same and has prayed that the matter be listed with some urgency. Full stop. Accordingly, list this matter again on the 10th of
Yes.
December 2025 for consideration.
Yes.
We'll have it on the
But
10th.
if for any reason matter can, then interim period will be cut. No, if
the petition-
they can make a mention.
Mr. Chaudhary, learned senior counsel, has submitted that in case the writ petition cannot be taken up for disposal on the said date, the prayer for
Interim relief.
interim relief may be taken up for consideration.
Yes,
Stop.
yes,
Parties
yes,
to
yes.
prepare accordingly.
We have to be fair to everyone. We are deeply obliged.
Act 2, the rest Act 2.
After being unfair, there is no point getting fair. No, I am always fair, but
I will go by the
Time to go to test the so before taking up the passport,
or you need to leave.
it may be taken before taking up.
Okay.
Item 33.
Yes.
That is the matter relating to the settlement of the
Settlement of?
Noyabasti by the market and at Hamnama police station for the year 1/7/2025 to 36/2026 for 1 year matter. The authority has issued tender offering bid money of rupees 1,35,000 from the bidder. The petitioner has submitted tender with a bid money of rupees 2,01,000 and the respondent has filed tender with a bid money of 1,49,000. So my petitioner was the highest bidder, my lord. The lord to kind of see the bank draft as page 27. Is the bank draft submitted by the petitioner, which is 1,01,100. Is the bank draft submitted by him and respondent number 6 is submitted 1,49,000, my lord. So the as per comparative statement at page 35, my lord. Comparative statement, my petitioner was told in the first bidder, my lord. Mundu Narjari and 1,01,100, my lord. And the respondent was 634 bidder, my lord. Plus he has submitted 1,49,000. So my petitioner was the highest bidder. I am entitled to settlement of the market under clause 12 of the need. It is in the my lord, page 15. Page 15 of the need. Clause 12. The competent authority shall make settlement with the highest bidder of all the necessary documents and government revenue are found in order in case settlement is made with the highest bidder. So everything is okay. Then there is okay, he has submitted all necessary paper and he is the highest bidder. So he is entitled to settlement matter. But instead of giving him, it was given to the respondent number 6, which is violated to the clause 12 and this paper.
Yes, sir.
Instruction awaited.
Instruction awaited.
Your lordship kindly see the earlier order, my lord. They were
Shall we read out the orders? I will read out the orders for you.
They were directed to file
The
affidavit.
first order says respondent number 2, 3 and 5 are specifically directed to apprise this court as to why the petitioner has not been granted the settlement in spite of the fact that the petitioner is the highest bidder. Okay. Then 4, 5 and 6 are directed to apprise this court as to why the petitioner has not been granted the settlement in spite of the fact that the petitioner is the highest bidder. Okay. Then 5 and 6 are directed to apprise this court as to why the petitioner is the highest bidder. Okay. Then 6 and 7 are directed to apprise this court as to why the petitioner is the highest bidder. in October, respondent shall bring on record their stand by filing an affidavit on or before 13/11/2025. Then respondent numbers represented Miss N. Chaudhary praised that the affidavit on behalf of the respondents shall be filed invariably before 1/12/2025. Now what do you say?
I will obtain.
You will obtain your instructions. Yes.
Department, Kokrajhar, Assam, making reference to inquiry report dated 28/5/21 by the Office of ADC Paska Mosalpur in connection with Army camp located at Bhojua village in Simla. It is clearly stated in the letter that the land was handed over to the army for temporary utilization in counter-insurgency environment by the civil administration in 2008, which came to be known as Simla Siop. Subsequently, the land was vacated on 21/12/2021 and handed over to the office of Paska of the Circle Officer Revenue Circle Dala Paska. After vacation of the land, so and so is in. Now, this, they have also annexed a vacation letter at page 67.
This is by the army.
This is by the army. This affidavit is by the army. And in their document, they have annexed at page 59, annexure 1 of this affidavit, the same very thing. Para 3, if my lord sees at page 59. Sorry, my lord, it's not company operated battalion, it's company operating base.
Company is smaller than a battalion. I think they have 7 companies and 1 headquarter company. So it makes 8 companies to make a battalion. Yes. Mr. Gupta will now explain how they came in possession.
But regarding that query, my lord, regarding possession, we have represented to the authorities also. My lord, we have given a specific page 50 of my affidavit, my lord. We have written a letter to the, my lord, the PTC Land Revenue Disaster Department.
Mr. Gupta, you're entering into the land. We are only asking about the entering into the land because we want to find out on whom would the liability lie for compensating
that records we are in fact praying from the authorities, which is the authority that they should give us the record.
It cannot be that the army was asked to come, you come and you sit down here.
This fact is not disputed also.
Number 1.
We were in possession, we vacated. Those things are not disputed. But my lord, the land records, it's for the revenue authorities to tell us. And it is them, my lord, who will make the assessment. And tell us, my lord.
The army had come here, not without knowing where they are going to sit down. They must have been told when they came here, they must have been told you will go and you will sit down there, you rest there. So a movement of an army company cannot be without documentation. There has to be some documentation that the company has to move to so-and-so place.
But for the revenue authorities, my lord, they cannot give anybody's land.
We are not on
land
that.
which was
We are
given
not
to
on
us.
that. We are for the time being, we are not concerned with the district administration. Please understand my question. I'm not fixing a liability on you as of now. So understand my question. The company to move of the army has to have a document saying that so-and-so has requested you, our so-and-so, this is your order, movement, or I think it is called a movement order. The movement order is there, please move. That movement order, without that movement order, the company did not move. You have not brought it before the court. The authority for that movement order, not before this court. So without anything being here before this court, we have to assume that you were there without authority. How the land was taken by the district administration, how it was handed over to you is a
No.
different issue, whether it was legally done or illegally done.
No.
But even when the army had the opportunity to place before this court the order that this is where the district administration asked us to move
No.
to Assam, to so and so location. And this is the order this company got to go to that location. It cannot be over the mobile telephone.
But I can
There
say,
has to be a document. Should we give you the opportunity now?
but my lord, in my humble submission, what would be not more relevant is that it is the revenue authorities, my lord, who have allocated us the land.
Show us that paper. Revenue is saying we don't know anything.
That is where the whole difficulty is lying, my lord.
So the difficulty will be
The revenue
between-
authorities are not able to give us the assessment. Under
the
what
difficulty will be
supervision,
sorted
my
out.
lord, they will assess that compensation. They have to notify us. We are ready to pay the compensation.
Okay. In that case, then we don't need you. Yes, revenue
But they have
authorities.
to tell us, my lord, under what provision
Deputy Commissioner,
they are assessing. Let them
BTC.
assess, my lord.
huh?
And my lord, before my lord,
Yes, Mr. Gupta wants
before my lord,
has something more to say.
on what the orders dated 3, my lord, will take the order past 3/5/24, my lord.
In the repetition.
Yes. 3/5/24.
Hmm.
Lord, here, Lord, certain instructions were directed to be sought to give, my lord, bring on record. PTC would decide as to the entitlement of compensation. And then, my lord, we take order dated 5/8/24, wherein Mr. B. Chaudhary, understanding council, submits that he would receive instruction as regards the assessment made with regard to the land of the petitioner possessed by the army authorities for setting up the counterinsurgency operation. Then, my lord, order dated 21/8/24. Again, my lord, Leonard Counsel with the petitioner submits that in view of the handing over of the possessional land in question by the army authorities person filing the petition, he would like to file an additional affidavit to bring on record the state aspect of the matter and further giving better particulars as to the compensation to which the petitioner would be entitled for the illegal occupation of the petitioner's land.
Yes, is Mr. B. Chaudhary still appearing for the BTC or not? Does
This
he
is
appear for
section-
the BTC? He appears.
No, my lord, there's a change in council.
There is a change in the standing council.
Again on 22/1, my lord, will third paragraph. 22/1/25 order.
Yes, what is the instruction received by you? Any instructions received till now? Huh? You have received a parawise comment?
Yes.
Yes, what does it say?
Express out this one. Our part, almost verification part and all.
Hmm.
Yeah. It has a limited power.
Hmm. So now the deputy commissioner has to assess the. What have you said in your affidavit? Your affidavit is by?
R11 starts at page 34.
Your affidavit by respondent number 11. Yes, what do you say in that? Hmm. Yes. Gopal Boro and Gopal Brahma are two different people.
Same person.
Huh?
Same. Brahma, Boro, same.
Gopal. Have you page number 49, Mr. Nair?
My lord.
Could not prove that he was in possession of the aforesaid disputed land before the army took over possession of the said land.
My lord, that is because there was a dispute between the Spracton and NDFP John Kalyan Good, and which has been resolved, my lord, that Annexure X, which has been taken on record, page 50 and 51, my lord, serial. That has been resolved, and they have no problem. They had earlier disputed, but now they do not have it between Gopal Brahma and the Practon NDFP John Kalyan.
Now tell us whether you are going to quantify the compensation or the BTC is required to compensate. Huh. Since revenue is a transfer subject, therefore the owners of ascertaining the ownership of the aforesaid plot of land rests with the BTC. This document says that ownership is his. So ownership is now settled. Now we are on the assessment part. Kindly tell us. Huh? Okay, we will give you we'll read out the report. Name of the original pattada Gopal Brahma, schedule of land so and so, said plot of land and residential houses so and so. No house rent has been received by the landowner, and we read in one part that he is the owner. As per latest Latmondal report, the plot of land is covered by Dag number so and so village, Hazua under Koklabari Musa, and is recorded in the name of Gopal Boro. Let us not go by page 49 because there they have said that it has to go to the BTC. This was in the year 2019. 8 May 2021. And just prior to that, on 4th of May 2021, the BTC has already decided. So there must be a communication gap. BTC did not send it to the concerned district commissioner, and therefore they came to this report. But otherwise, 4/5/2021 says that it is the land in his name and whatever and whatnots. Now, if someone had made a claim, some Jono Kalyan, they have also given a document saying that we do not have any objection. So let us not now have any qualm over the ownership. Let us put it at rest. Now we have to understand who will assess it and as per what, because it was user of the land. Where is it? Vidya judgment.
My lord.
Yes, madam. Don't leave him standing alone. Give some support to him. The assessment has also to be done by the circle officer.
Circle of
Okay. So, Mr. Circle Officer,
jointly this assessment, this assessment part. declared jointly,
we are not concerned whose help you take. We will not go into that part of it in running into your administration part of it. Keep us away from that. We will only say that the circle officer with such assistance that he may require shall give the assessment of the market value, market rate rent of the property as a whole, including the houses and the land which was in occupation of the Indian Army. You would produce before us the assessment of the rent and how, what sort of a rent is it? What was it called? Default in rent is recovered at what rates from your persons when they continue to illegally occupy a certain plot of land. As per the calculations, the payment will be made. So if you give us that particular notification by the estate officer, I think the estate officer fixes the in what multiples it will go on increasing per month. Let it not be very heavy. I understand that from 2008 to 2019,
21.
we will left with nothing to defend our country if we go on paying everything. Here there was a clause for this compensation.
There were certain other judgments as well. In which, if this pertain to acquisition, if land is taken possession of before issuance of the preliminary notification, it is 15% of the market value, which is taken to be the interest, and that is taken to be the compensation for the period of occupancy. These are certain other judgments, my lord. 2023 SEC Online 63, 16, 13 SEC 412.
So how much time would it take for you to make the assessment? Give us something within your comfort zone. There is no difficulty. He has waited for some time. He will wait for some time more. But we need that assessment part. 4 weeks? 4 weeks, 6 weeks? Huh? 6 weeks.
End of January, maybe.
No, we'll keep it in the first week of February.
Mild.
First or second week of February.
Mild.
Heard Mr. P.D. Nair, Learned Counsel, appearing for the petitioners. Sorry, petitioner. Your name, sir?
B.C. Musahari.
Mr. B.C. Musahari appears for the as the standing counsel BTC.
Respondent number.
For respondent number
3, 6, and 12.
3, 6, and 12. Mr. H. Gupta appears for the respondent number
1, 10, 19.
Ms. Borman appears for the respondent number 11. All complete. Not Hagigul respondent number.
Complete.
Huh?
Complete.
All Hagigul. Huh? Mr. Bhattacharjee for respondent number 2. The claim of the petitioner in this writ petition is that a certain plot of land with constructions thereon had been occupied by the by whom? By
the Indian Army.
By the Indian Army. Where is that letter? There was a letter I was by the Indian Army. By the Indian Army from 2008 to set up a company
operating base.
Operating base. Full stop. When the petitioner was not paid any rent nor compensated in any manner, comma, he had approached the authorities, and when no reply was, and when the representations went unanswered, the petitioner approached this court by filing the present writ petition. Full stop. After filing of the writ petition, comma, the land and the constructions thereon had been vacated by the Indian Army, and different affidavits were filed by the contesting respondents, wherein the ownership of the petitioner over the plot of land and the constructions were questioned, and the stand taken by the Union of India was that since the assessment of the rent and the compensation, if any, had not been provided to them by the state authorities, comma, they were not in a position to pay the same. Full stop. The Learned Counsel for the BTC has drawn the attention of this court to a report dated to the parawise reply submitted by the circle officer of Joloh Revenue Circle, Joloh Ghat, BTAD 2, the secretary within bracket Revenue BTC Kokrajhar, wherein it has been clarified that as per the Lot Mondal report, the plot of land is recorded in the name of the petitioner herein, and on the said plot of land, Pakka houses exist, which were then used by the army camp. Full stop. The circle officer Joloh also received a letter from the office of the Deputy Commissioner Baksa asking for a detailed report, and the said report, it was mentioned as follows. Pencil mark Roman 1, 2, 3, 4 isn't it? Yeah. It was further reported that the disputed land was under the possession of the Indian Army at least till 4/5/2021. When was it vacated?
But 21/12/21. There is a letter.
The Learned Counsel for the petitioner submits that in fact the land and the property was vacated by the Indian Army on
page 67, 22/12/21.
20.
But in the affidavit they say 21, but the document is page 67 is the document.
We'll go by the document.
My lord, page 67.
This letter is also dated 21. So,
my lord, page 67, letter dated 22/12.
So it is of 2021.
My lord,
so it cannot be 22.
My lord, 22nd. He said. In the affidavit they say 21st.
One day here.
It doesn't matter.
One day here and there. Yes, I was vacated on 22/12/2021 as per the report of the circle officer. Next, it is seen that it is seen that it is not in dispute that the land had been occupied, the property of the petitioner had been occupied by the Indian Army, which which is stated to have been handed over by the district administration. The issue that requires the attention of the court is the manner in which the petitioner is now required to be compensated for the use of his land and property by the Indian Army, which is alleged to have been handed over by the district administration. when no rent or compensation had been paid to the petitioner for such user. In such circumstances, this court directs the circle officer of what?
Respondent will.
The circle officer of the Jolagh Revenue Circle, Jolaghat District, Baksa, BTR, Assam, within bracket, respondent number 12, to conduct an inquiry, if required with the assistance of the deputy revenue authorities of the government of Assam, to assess the market rate. What do you say? You will get the rent, market value.
Market value will come when there is acquisition. Market value of the land, my lord.
Market value
That
of the
is
land.
usually in acquisition proceeding, the compensation is determined with reference to the market value of the land. But here,
No, the
since
market rate rent for user of the property of the petitioner by the Indian Army and place the same before this court in the form of an affidavit on the next date fixed. The learned counsel for appearing for the Indian Army shall place before the court the notification on the basis of which arrears of rent are calculated when premises under the defense estate officer are occupied by persons who are not authorized in law to continue such occupation. Let this matter be listed after 6 weeks. Let this matter be listed in the second week of February on a date to be fixed by the registry, by which time the respondent number 12 or 11.
12 is the PTC circle of.
Shall ensure that the assessment of the property is made. Full stop. Mr. Gupta shall also ensure that the required notifications are placed before this court. Full stop. The instructions produced by Mr. Musahari is kept on record and marked as annexure. Why could we go to her? Why?
I may be firm.
Please.
While vacating the land, they have caused some damage to the property. If a direction could also be made by not to
the assessment of the assessment of it's a Koibudlu circle officer that add and also assess damages caused to the property, if any. That they will see whether any damage was caused or not.
Yes.
List in the second week of February as directed.
Deeply.
Mr. Gupta, the longer we keep pushing the case from this side to this side, the longer will be the period of interest and the, is it not?
Supreme Court now says 15%.
He just smiled.
Deeply obliged.
Yes.
My lord, that has been, my lord, it will be directed to apprise him whether it has been the authority has rejected the machine, my lord, within the 10 days.
Oh, yes.
My affidavit in opposition. Page 23.
Page 23
of my affidavit in opposition. After the goods were delivered, the machine was not working, and the interest came in, and that is the here,
yes.
It is to inform you that as per the departmental complaint on CR machine supplied by your company through authorized distributor so and so, as a petitioner, by challan number so and so dated so and so, a committee was constituted to verify the machine. The committee after verification passed their reports as under. The monitor of the machine is made in China. as reported by the orthopedic department, same quality machine costs around 9-15 lakh, whereas the cost of aforesaid machine is 33 lakh. The committee is very much concerned in view of the product at such high price. Four, my lord, since the machine is not properly functioning from the beginning of its use, the committee views for return, cancel of the product. My lord, if the law should also come to page 30 of my affidavit.
30.
30.
Yes.
The engineers, they have given the description of the product. Page 30, my lord, handwritten matter.
This is by whom?
The PPL, the manufacturer.
हाँ, ठीक है.
Here, my lord, if you lost me, see the column, my lord, the written column. From the day of installation, image of formation found faulty and blurred. Delay in so shoot and sometimes silence images. So there is a fault from the very day of first day of the installation. And that's why I'm invoking the clause.
No, these are letters given to you by you to the BPL.
Well,
no difficulty at all. We just want to know that he had supplied you the machine on
my lord, 16/7/2020.
21.
2021.
21, my lord.
You had a time frame till 27/7/2021 to reject it.
Well,
then when did the discussion?
My lord, that CRSE has been, my lord, uploaded as per the requirement on 21 August 2021.
Where is it?
My lord, my lord will find on page 46 of my
Page
petition.
46. Now
46
kindly
of my
go to page
petition.
46. Consignee receipt and acceptance certificate.
And my lord, Nectar 8, that is
Where?
seal that
Is
has
it
been
so?
uploaded.
Now this was given on 17th of July 2021.
my lord.
The right of the customer to have the machine replaced, done anything, we are keeping that intact. You have that right. That right will lie against the company.
If I may, my lord, in my humble
Ah,
submission,
yeah.
my lord, it's the seller, my lord, the petitioner, in the agreement, my lord.
Never.
If I may, is the agreement, my lord, again, my lord.
Yes, please. Convince us, otherwise we are so happy.
Page 51 of the,
51.
my lord,
Yes.
the role of the seller, my lord. At clause 10, my lord. The seller shall be solely responsible for the goods, services, including without limitation, the applicable guarantee, warranty, shall fall them. And the title for giving the correct and accurate details of offered goods and or services, indicating product specification, quantity, which can be supplied of a specified period time, etc. As per
Yes.
catalog.
Yes.
This is also the responsibility of the seller to provide the.
Very
and
true.
if you're lost, me again, come to page 71. 72, my lord. In clause 4.
Yes.
No payment shall be made for rejected goods or service.
True.
After intimation of the rejection, part rejection by the buyer, which we have intimated. At
The
page,
seller, no, that intimation, that rejection has to come as per clause 1.
Yes. Help one.
Within 10 days, even after you had accepted it on 17th,
Yes.
you could have still rejected it up to 10 days.
the
Then
committee,
there would be a big issue. Then we would sit down to decide whether the acceptance is correct or the rejection is correct or this is correct or that is correct. Till the 10 day, you have done nothing.
it is there, but in the clause 4, the part of the where it is intimated, that is after the installation, we have been, in my affidavit in opposition, we have stated.
Then you should not have uploaded that acceptance. Matter fine. Someone is in a hurry to upload the acceptance. They
Yes.
uploaded it.
Another
Hold it
fact,
trust.
remains that it's the faulty product, the.
And
for
we
the-
will ensure that you will have the liberty to have the item replaced, to have the compensation paid, since it is medical services, to claim whatever you want to against the manufacturing defects. If the seller is liable, catch him. If it is the company, catch them. There's no difficulty on that part. That you must continue with a bad machine
It's still lying.
It cannot be our jurisdiction to say so. It will not be in our minds to say so, that you should be handed over a bad machine and you should. But the problem is, once you have accepted it in terms of the contract, the acceptance has been given to them. The money was required to be paid to them within a certain period. Held up the money. Is it not? Is that permissible? Tomorrow, if you go to buy a vehicle, buy the vehicle, pay the money and then you bring it back. Here it is a case of a contract where the seller gets it after the delivery of the goods, for whatever reason. So the goods were delivered to you. You accepted the goods. When you had 10 days time within the contract itself to accept or not to accept. It is only on that ground we are saying that he is entitled to the payment of the supplied good. And now to make that.
My submission. And also, I'm operating the maintainability. There is an arbitration clause specifically. My only submission.
Have you filed your affidavit?
Hello?
Have you
Yes,
filed
I
your-
filed.
And have you taken the ground of arbitration there?
Yes.
And have you replied to it? What do you say?
It is TSI is established under the TSI 1948 and it is instrumentality of state method.
Who?
TSI.
Oh.
TSI is in hospital that has been established under the Government Act. It is an instrumentality of state and it is discharging public duties. So it can be having some arbitration clause.
Railways is a direct state. Still, it has to sit for arbitration. People is directly state.
Arbitration is clause. What I'm trying to substantiate is that having a arbitration clause does not debar my lord. It is amenable under 226. And at that minute has
It would still be, but the kind of dispute being raised.
Well, here, my lord, only the violation of the norms. And my lord, I would like to draw your kind consideration as regarding my lord that a memorandum issued by the financial department in your my lord, saying, my lord, reiterating the same thing, my lord, that has been issued to prompt my lord payment to those vendors, to especially my lord that middle, small, and my lord medium and entrepreneurs, reaffirming the same thing that the payment.
And what do you say about supplying him a machine which is
my lord,
not being used for the last so many years?
My lord, my lord, not used by them.
It could not be used by them.
No, that is their contention. Here they have, my lord, that the installation was made in the, my lord, on 27/2021. Thereafter, my lord, they have, my lord, there is enough time was there, adequate time was there. My lord, they have not reject my, my lord, they have not rejected our machine, our item. Thereafter, my lord, they have, instead of rejecting our machine, they have uploaded this CRSC.
When is the first time you informed that the machine is not working properly?
And in my affidavit, we have immediately.
Not immediately.
You have stated immediately.
Just he has referred a letter, my lord.
You were silent the whole time you and I were interacting. Remain silent when he and I are interacting. We'll come back to you.
Yes, as part of the records, this is the concept after constitution of the committee, it was found defective. And
so the first time that you intimated him that you were not happy with the machine is in October. Is it?
Though in my affidavit is if your lordship also come to page 34A, my lord, the doctor they have also intimated the thing that right from the day of the installation, it was not working.
Where have you stated?
My lord, at page 34. So it's after October.
That is what we are saying.
And I'm only raising here maintainability because the arbitration process here, my lord, it also involves my submission only, my lord, if I may, my lord. It involves disputed question of fact whether the machine was working properly at that time. That is because fact remains that it's still working vacant and it's for the purpose of the public. It's the ESS of the government is the hospital because it distributed the benefit for a socialist. And they have not any reply to the arbitration. Arbitration. I've raised a specific case. That is my submission. I leave it up here.
So now we have to decide whether the arbitration clause will be enough to reject the writ petition, allowing you to take up appropriate forum, and if we decide the writ petition, whether the non-payment of bill is correct or not. Amount is admitted.
Pardon?
That is the amount of the, that was the amount fixed upon is admitted.
Amount, the amount of the machine.
Hmm.
That is the amount. Certificate. Your lordship, sometime I may also take some judgment regarding the arbitration.
Yes, yes.
But
please.
I had, was not prepared. If I may, I can give some time.
Yes. Well,
Just the whole,
we'll keep this as
because
CAB.
even I have disputing on the contract only.
We will keep this as eto oha. We will fix this on the next Friday. For delivery, today's Friday. That will be, what will be the date? 12th. We'll fix it on 12th for delivery of orders. Whatever written submissions or judgments you want to give, you give before that date. Before that day. So that on 12th, we'll pass our orders on this.
I will file the next week.
Huh?
We'll file a written argument on the next.
Before 12th.
My lord.
Before 12th. So that I can incorporate those things in the order, whatever submissions you make. Okay. Parties have been heard at length. Mr. So-and-so appears for the petitioner. Mr. So-and-so appears for the respondents. Parties have been heard in length. List this matter again on the 12th of December 2025 for delivery of orders.
Item 9. I've spoken to the authorities, my lord. Now, contention is, my lord, after the process for determining the contract in the clause 62 of the terms and conditions of the contract was initiated by the railway respondent by issuing the 7 days notice, my lord. Railway did not incur any responsibility or liability to respond to that representation. There is a reason, man. If lordship comes to that representation, that is at page 125. This is not in response to the 7 days notice, my lord. They have not responded to the notices, 7 days and 48 hours notice. This is in response to some other letters which were issued to him prior to the 7 days notice. And those documents, my lord, were not relevant as on that day. So once the process started for determining the contract under clause 62, I'll place that clause, my lord. The railway did not incur the liability to respond to this notice because it was not in response to the 7 days notice, and thereafter the 48 hours notice was issued, my lord. Even that was not responded to, my lord. What option did the railway have other than to terminate the contract? That is why it was terminated. Now there is another aspect to it, my lord. Since there is an arbitration clause, these are all disputed. If your lordship wants to decide the matter, we have to decide disputed questions of fact. Whether in a writ petition, your lordship would like to enter into those disputed questions of fact.
Yes, Mr. Bora.
Yes, madam.
We were proceeding on the premise that these letters were in response to the notices. Apparently, they are not.
But my lord, otherwise also if it is not in response to that notice, my lord, but Annexure 7, page 125 letter and page 127. Page 127 letter, it was submitted after submission.
After notices.
Yes, my lord.
Yes, true, but they were not in regard with the notices. They were not connected to the notices. So therefore, the office which was giving you the notice.
Yes, my lord.
They never tagged these applications with the notices for them to consider.
But my lord, the authority who issued the notice, it has been addressed to that authority only.
If a writ petition is, if an affidavit is filed connected with some other affidavit, with other writ petition, am I supposed to take it on record on this? It is the same High Court.
the contract agreement. Reference is the contract agreement. Under
But the
same
notice
contract
goes from
agreement.
some other end.
My lord, being a contractor, my lord, this kind of technicalities he may not be aware of, but otherwise, my lord, the facts are that is the fact, my lord, because the fact which has been narrated in page 127, my lord. Page 120, they have not responded to it.
But whether they were required to respond to it in when these facts have been brought before us.
Because, my
If
lord,
we
the
decide it.
variation clause is there, my lord.
We understand. Then
Okay.
again we see that the variation is for
The rate. Which is
your
not-
prayer is for variation of rate. That clause is for something else.
My lord, it is not exactly rate, my lord. Rate, my lord, plus minus 25% can be varied, my lord.
Where?
That's
Wait, that
quantity
is-
variation, not rate variation.
That rate will be varied once the work is varied.
Yes, my lord. It is
Once the
rate-
work is
rate-
varied,
rate
whatever is the total amount of the work, if
Yes, my
your
lord.
work is varying between 125 to 140%, then 98% variation will be allowed to you. That is when the work is being varied.
My lord, rate variation is a consequence of quantity variation, my lord. That is a consequence of quantity variation, my lord. If quantity increases, my lord, obviously rate will be increased, my lord.
You are required to take a call. I decide or you decide. Those issues we do not know whether we can go into. Because with 127 and 129, 127 and 125 not being in response to the notice, the termination we cannot go into now because you never responded to it. Even if these letters
My
did
lord.
not deal with the, even if these letters did not deal with the any allegations made in the notice, but if it had a reference to the notice,
Yes, my lord.
we
But
would
my
have
lord, only the reference is not there, but otherwise
nothing else is there.
No, allegation or the issue is
No, they say that you are not completing it, and here you are saying that please refix the rate.
Yes, my lord. Because here we have intimated that what are the difficulties in completing the work, my lord. The subject
No, the
matter,
reference had to be here somewhere.
only the letter number is not there in the reference, letter number and date. Otherwise, it is in respect of that work, that allegation, my lord.
Like we hold the respondents bound to their letters,
Yes, my lord.
bound to the observations that this was not followed, that was not followed, this does not reflect. We have to bind down the petitioners also.
Yes.
If we
That is
bind you
true, my
down,
lord.
then this is
But-
no reply.
Apart from referring to the notice or the termination notice, but otherwise, my lord, the issue is which has been narrated in our reply, my lord, in our representation. The issue is same, my lord. The issue pertains to that issue only. Why they could not complete or they could not proceed. And otherwise also by 19/1/2022 letter, he had informed that
It already stood terminated by the
No.
day.
it has been terminated on 21/2022.
After that 48-hour notice. The
Yes, my lord.
48-hour notice had elapsed by that time. They're issuing of a letter later on.
They have issued a letter when after we informed that we are resuming the work, my lord. 19/1/2022.
21/11, then 19/1. How do you say they have received it?
No, they have not denied in their affidavit that they have not
This
received it.
19/1, have you admitted?
They have not denied, my lord.
Not, I've spoken to them, they have said that they have not received.
No,
it.
no, in
They-
affidavit they
and,
have not.
my lord, This will have no consequence because the notices were not, never
They
responded.
responded to that is the
That
whole.
is the main issue, crux of the issue, my lord. They had no option other than to initiate. the action which they had taken.
Yes, Mr. Bora, tell us.
My lord, the fact that I have placed, so your lordship, lordship considers, my lord, because apart from the notice and reference number, but it is the reply of that issue. Why you have not completed? 7 days notice has been given to resume the work. Why he could not, my lord? That has been written in their reply, in their representation, my lord. And ultimately, they inform that they are resuming the work. And in respect to the paragraph 9, annexure 10, they have not denied that they have not received it, my lord.
When assuming it was received, my lord, the 48 hours.
"48 hours notice was issued on, my lord, 25/11/2021. So why they were waiting till 21/2022 to issue the termination? And that too after we approached, my lord, because in between, my lord, there was some talk and negotiation between the petitioner and authorities.
What was the contract for?
Contract for respacing of SC sleeper. And that letter, termination letter 21/2022, that has been communicated to the petitioner on 28/1 only, my lord. In my paragraph 10, I have stated, I submitted the letter, my willingness to resume the work on 19/1/2022. So they served me with a termination order on 28/1, my lord. In paragraph 10, my lord, page 9, I have stated. Paragraph 9 and 10, your lordship may peruse. My lord, there is some sort of arbitrariness on the part of the resident authorities.
The performance guarantee has not been encashed till now.
Encased, my lord. Yes. Obviously, that will be subject to outcome of the writ petition, my lord. And paragraph 10, my lord.
We will keep it CAV, see what we can do.
Yes, my lord. Obliged, my lord.
Take down the attendance. Huh? Wait. CAV.
Deeply obliged.
Item 28.
আজি এটাই চিভি হৈছে ডেলিভাৰ এটা সেইটোতো সেইদিনাখন হ'ব যি হ'ব কাগজখিনি অহা চিভি এটা হৈছে য়েছ ছাৰ
May I please, Lord? My lord, this is my lord. Matter relating to eviction, my lord. During the pendency, my lord, the petitioners have been evicted, my lord, from the revenue land, my lord, of Khas land, my lord. Our case was, my lord, we are within the limited boundary of, my lord, revenue, land revenue, my lord. So this is, my lord, arbitrary eviction, my lord, without procedure, my lord. And kindly see, my lord, our records, my lord, revenue received, my lord, page 26 to 39, my lord, of my writ petition.
Revenue receipts are nothing. I was told in the morning by some council that I can pay the revenue for the
Yes, madam.
Lotasil field.
Yes. They don't confer any title.
Huh?
I have
He has submitted.
Otherwise,
Let
my
us,
lord,
no, show us something. Show us how you claim.
then, my lord, kindly see the photograph, my lord.
Of the houses.
Of photograph of, no, my lord, of AF mark, how they have marked, my lord. One house is AF, my lord, Assam Forest. Immediate another house is, my lord, KL, Khashland. How, my lord?
Geo positioning.
76, 79, my lord.
Geo positioning, perhaps. So this KL has not been demolished. Okay.
Some KL is there.
No, now that they have demolished it.
KL, my lord, KL, my lord, remark. Department has remarked as, my lord, AF. Kindly see page, my lord. I have.
Yes, Mr. Gogoi, by the last order of this 18/9/2024, you were required to carry out the eviction only after consulting the respondent of 4 and 5. Now, where is that consultation?
Yes, we have filed affidavit. There was a joint verification with the Revenue Authority, which was earmarked, we have demarcated the area. Though, my lord, the demarcated area, my lord, you will find it, the affidavit at page 83. Before coming to that, my lord, assuming for a moment they are correct also.
Did you give them notices before this eviction?
No, my lord, that is the, I'll try to explain, my lord. In forest land, since, my lord, there's a proclamation, since there's a notice, there's a public inquiry in forest land, before we proclaim a reserve forest, there's a section 5, section 4 to 20, section 4 to 17 is followed. Application is made, inquiry officer is appointed to inquire into settlements. So notices were given, my lord, but that argument that no, we have to be that argument of Salekuddin, 18.2 of the Assam Land Revenue Manual wouldn't come here, my lord. That's it. That's it. Yes. Because even Lordship has the book, the Assam Revenue Forest Manual. There's a citation up there. Dil Bahadur Chetri. Anybody who enters forest knowingly or unknowingly is liable to be evicted. And that department, Assam Forest Land Revenue Manual, Chapter 10, Regulation 4. It says forest lands are excluded from the operation of the settlement. And thereafter, we also had this.
Now,
we are facing a contempt.
Where is the notice that you had given them?
Notice, my lords.
Notice page 75 of my writ petition.
Additional affidavit.
No,
it was 75 copied.
75A, my lord. 75A.
And, my lord, regarding Gwalpara, situation is a bit unique because there was a suo motu PIL registered by this Honorable Court Division Bench, and there was a contempt because we are complying with the direction passed in that suo motu PIL that you carry on evictions in the reserve forest of Gwalpara. In reserve, Gwalpara has 56 reserve forests. So we are complying with that. That contempt is still going on. Where High Court is monitoring, the division bench is monitoring this eviction. And the other part also, 52 petitioners have come before Lordship. 52 petitioners, 53 petitioners. Now they have filed an additional affidavit, annexing some details. I just counted, my lord. They just tell you with the 11 number of petitioners.
Yeah.
Other petitioners, they have no, even if you disputed also, they have no record. There's nothing. So that apart, my lord, we have I have the instruction of the DC also with me.
Saying what?
Saying same with they have even the joint survey, they have went point beyond that, and they have described everything with the schedule, with the geo coordinates also, that this land falls under forest.
Now, my lord, in Goalpara district, my lord, revenue department has become, my lord, landless. If today, my lord, some schemes are to be implemented in revenue land, my lord, there would be zero, my lord, in revenue department, no land. My lord.
Land is there for the
Land
forest.
is there, but revenue
For
also.
the forest, for the forest.
My lord, this is not the case that
You
even
can't
where,
convert forest
lord.
land into revenue land.
my lord,
Just
no
because
person, my lord, no person will,
we
they
did
will,
it.
they will, my lord, try to stay in the forest land, my lord. We are not making any submissions to wrong premise, my lord. We are to say only, my lord, we are only to say that our lands, my lord, we are staying in the, my lord, revenue land, my lord. First land, my lord. But that first land, my lord, has been stated to be here, my lord, forest land. And my lord, kindly see the page 76 to 79, my lord, photograph. How they have changed this, my lord. KL and AF, my lord. And if, my lord, forest land, my lord, how there be, my lord, schools, my lord, then electrification, my lord, water supply, my lord, Anganwadi centers, my lord, PWD roads, my lord.
The demarcation has been done
Done,
for
my
the
lord.
forest. Goalpara forest has now been demarcated.
Yes, my lord. Eviction has been completed.
No, eviction completion, completion. we are not there.
Demarcation has been
The
done.
Demarcation.
Done, my lord.
Done.
In many
Demarcation
cases,
done.
what has happened, Lordship, after proclamation of forest, revenue records have not been rectified. In some cases,
True. We have dealt with a certain case.
yes, because of that, these issues are coming up. Because people are under impression, not they particularly, some touts are there who try to sell those lands to those people who are needy people, and this kind of situation comes up.
The revenue records not being corrected. The people checking the revenue records found that these are
Forest,
no, they are revenue lands because the revenue records were not corrected.
my lord.
Then whom should the people trust? Can you tell us that?
No, there is another aspect I like to point
No,
out, my lord.
let us stay on this respect. You have taken me from this to that to this to that to this, and I forget where I was starting at. We will not let that happen now. We'll catch you in.
My lord, in
We'll put you on
Goalpara
one position.
specifically.
First,
Goalpara
explain to
specifically,
us. The admitted position is that the revenue records did not show the particular piece of land as a forest land. You say the revenue records were not corrected.
No, I'm not
We
saying
will
in
not
this
go
case, my
back.
lord.
No, we will stick to this case.
Then I won't be pressing that argument in this case. That's
The
not.
press the arguments which we
No.
can decide this case.
In this case, my lord, there was a joint survey. DC has also given instruction. KML has been marked.
And has the DC filed their affidavit?
They have not filed instructions. Are there.
When did you get the instruction? There is no use for me directing a personal appearance of the council concerned for not filing the affidavit. Can I do that?
Almost an anniversary.
This, no, you are required to take out that.
I'll be.
You are required to take out that joint survey before carrying out the. Before carrying out the eviction part. So this was after the eviction, after the order of this court.
After the order.
5th of November 2024. And when did you carry out?
24 and 25th September 2024.
Where do I get the date?
My lord, I have mine, sir.
No, eviction was carried out on 24 and 25. I want to know when was the joint survey done?
Joint survey. 22nd September. It's reflected in my affidavit.
Do you want us to read this instruction? Do you know how the joint survey was conducted on 22nd of September?
I have sent a separate, we have minutes. We have minutes.
Verification, how do you carry out verification and demarcation? By making minutes?
No, my lord, there's a field visit. And
where is it? That is what I'm asking you. Where is that field visit? When was it? The date? One simple question, the verification date. In this connection, a meeting was convened on 22/9/2024 in the office chamber of the district commissioner. What did you measure, sir? The chairs and the tables?
Yes.
I have the minutes
My lord,
there before me.
minutes, my lord, with map is
I
there.
have the minutes.
No, I have something different. I have the schedule of the land and the area, my lord.
Perhaps that one photograph is missing.
Area is there, my lord, demarcated.
Huh?
Demarcated area.
This is the land of the forest is demarcated in this piece of paper, we understand. We understand you all sat down and said that this is the area. His house falls within that area. Where was that field verification is our only question, sir.
That is contained in his own petition, my lordship, those photographs. Where it is marked Assam Forest, where it is marked KL.
Let me put it to you again. This court, after filing of the writ petition, had directed you to carry out a joint verification. Joint verification, when you are going for eviction, it has to be found out that this particular house falls within the forest area.
My lord.
Am I clear now?
Yes, yes, I got it.
That house,
Beyond
that
it.
house which was broken, what is the coordinate of that house? Does it fall within that boundary of the forest area?
My lord, it
You
is there.
cannot do it sitting in the DC's office.
No, my lord, we had to carry out a
Go
field
there.
verification.
What is the date?
It
I
is-
don't even want to know who went. I want to know what is the date when you went.
It is reserved day for the operation has been set forth on the 26th of
Operation day is
26th.
Operation day is
26th, my lord. And then
surgical strike done.
26th
When
was
did
done,
you
my
plan it?
And then we found area to be evicted 55 hectares, numbers of household to be evicted
Again-
450.
Again, you are not telling me the answer.
My lord, I can clarify it.
Huh?
My lord,
Here,
I can
here
clarify.
you have this piece of paper that is 27th of October 1996. You have given coordinates. This is of 1996, the schedule. We are not for once questioning it. That you have demarcated out, this is the forest. We are not questioning it.
When it was
His house
said,
is within that coordinate, outside that coordinate, there was supposed to be a joint verification.
My lord.
When was it done? This court required you to do it after filing of the writ petition. All the meetings, we are not doubting the truth of it. What we need to know is the date of the joint verification. If this eviction has been done without that joint verification, with all good intent, an act done wrongly, and if the joint verification has been taken place and you have marked the house, this is the coordinate within the boundary,
Well,
you will not have a case.
Exactly.
You will not be here for the
Fix
next
this
half an hour.
matter on Tuesday.
Hmm?
First, we'll fix this matter Tuesday.
On Tuesday, we have a different bench. That is it.
I'll leave it to
You tell us.
already because eviction has been done, finished.
True.
There's nothing. And out of 53,
Now, even if we find that that eviction point was beyond the reserve forest area,
well,
then you construct his house. If
That-
it is within the
No, no,
reserve
no,
forest
that-
area, we
no.
dismiss the petition.
worst case scenario, which
Ah.
I will face, I may face, admitting his claim, that will also be confined to that disputed titles of that 11 petitioners. only.
That
Yes.
will decide when the matters come up.
Yes.
We are not on that.
Secondly, my lord, the other issue
We
which
are not
I
in
may
that.
again face the fire of the
We-
court, that
No.
did you actually carry out
Very,
anything?
but let us make one thing very clear, Mr. Gogoi. This court is never on fire. This court is always routine.
Right.
So our tones may vary, but the intent always is.
I got it. My lord will fix it.
So
I'll
all we
come back
want to
whatever
know is
instructions are required.
your meeting took place inside a chamber, admittedly. This court wanted you to do a verification. That verification cannot be inside the chambers. Cannot be. When you are breaking down houses saying that they are within the forest area, it has to be marked.
We are
This is
carrying
the
on my
area.
lord, past eviction. We know, I'm very confident we have those. We can bring it. We have.
That field verification, that the houses of the writ petitioners, whatever the address be given, whatever has been identified as their house, they were marked. They were marked on the geo-positioning system to show that they are inside that particular boundary. That is what this court wants. This court,
Exact data field
it is in the first order of this court that we are not stopping you from evicting. The question does not arise. Forest is forest.
And in that case, my lord, no, will confine my lord, because though he has spoken a lot of things, they have stated a lot of things.
Let us not.
But my lord, the photographs which they have annexed is one of LP school, is one of some house, random house, one road, one TWSS.
There are something more. Behind that also something more.
Some houses are marked AL 79.
We have some more.
77.
Yes.
79 series.
76.
76.
Page 76. Page 77, you see. Now, if these are the houses which have been demolished, including the school, just file an affidavit saying that these are the coordinates he has given.
Yes.
The coordinates you have on your record. Show that this coordinate is within the reserve forest.
Yes. I'll answer this, which we have marked A.
And if your petitioners have more premises than these, suppose there are 53 petitioners, you have given photographs of schools, which obviously do not belong to your petitioners. They cannot belong to the petitioners. They have to belong to a society or something. There must be a managing committee. There must be a governing body, something. You are not the owner of the school.
School is the government school.
It's a government school.
Government school.
So government school location, if you have demolished a government school, gone ahead and demolished a government school, we do not know, inside a forest land. If you say that the government himself was building schools inside the forest.
And two Anganwadi sectors also.
Anganwadi centers and all that. The zeal we understand, Mr. Gogoi. We require the forests to belong to forests.
But
one deer here and there, it's
schools and Anganwadis are permissive. Forest Rights Act has an exception of.
But the allegation is that even they have been damaged. Allegations.
We'll see.
So
we'll confine my stand to the
of
areas, my lord.
all the 53 petitioners who are claiming that they are holding land,
well,
provide them the geo-positioning of the land that they say were theirs. Whether it is government khas land, whether it is reserve forest land, whether it is whatever land. Give them the geo-positioning. Their geo-positioning is on record. Is it not? Have you filed this 27th of October 1996?
Only few of the houses, my lord. AF and KL, few of the.
I'm saying give the 53 list to him, the geo-positioning. What is the difficulty? They must know their lands. Photographs have been given, giving the position. Give them the position. Let us find out whether it falls within this. What is this? This 27th of October 1996 at a bearing of degrees. You see, these degrees are given. The geo-positioning is given.
Yes.
Just compare it. Finish the case. Otherwise,
those we are not having those.
They will file an affidavit to that effect. We will take this matter up after 6 weeks. 2 weeks, kindly file your affidavit, the revenue authorities. File your affidavit saying that for our identification, this is the land. This is what happened. Forest would bring on record this 27 October 1996.
Well,
the positioning is here.
Yes.
This is what you worked on. You do it within a period of 2 weeks. 4 weeks, we allow him to have his instructions on the geo-positioning part. We take it up
Well-
after 6 weeks. If he can dispute it, or if he cannot dispute it.
Well,
Will that suffice? Yes. Yes, that part is also important. That field verification date.
I'll apply it.
Because that was a requirement of the order.
Yes,
We have not tried to bring it in. This court observes and directs that respondent shall do so after duly consulting with the 4 and 5. That verification.
If that language is interpreted, we have done.
No, this consulting is sitting inside.
Consulting
We
is
have to
done.
understand it reasonably.
My lord, I get it. We have those-
Consultations take place
We'll bring one.
in this corridor, and consultation takes place after 8:30 also,
My lord.
with all the equipments open. So when we say consult your lawyer, we don't need talk in the corridor, do we? Yes, heard Mr. So-and-so, Learned Counsel appearing for the petitioner. Also heard Mr. D. Gogoi, Learned Counsel appearing for the Department of Forest, Mr. Das appearing for the respondent number. Huh? For the state respondents, other state respondents, huh?
4-5.
The counsels for the respondents have submitted that they have received their instructions in the matter, and an opportunity may be afforded to file their affidavits.
My lord, I have filed. It will be on additional. I filed.
The process file. I have not got that.
No,
copy.
please find out, Mr. Gogoi.
I have this.
We do not have. Do you have a receipt?
No.
I have it with me. I don't know. I'll check with my.
Here we do not find anything. After
My lord,
printing.
I'll think. Maybe sometime. it happens.
There is an order saying that. Oh no, it was about the additional affidavits. Yes. Then what did we say? To file their affidavit in opposition. Full stop. It is seen that let the affidavits be filed within a period of 3 weeks from today. Full stop. The petitioners would be at liberty to file the response to the affidavits within the next 3 weeks thereafter. Full stop. The matter relates to eviction from forest land, alleged eviction from forest land. Full stop. The respondents and the parties would ensure that the pleadings are completed before the next date of listing. Stop. List this matter again after 6 weeks. February. List this matter again on the 16th of February 2026, along with the affidavits required to be filed by the parties. Stop. In all the matters where the eviction process is under challenge, mere geopositioning of your boundaries of the forest and the position of these petitioners, it solves the whole issue. A
not
degree
all-
here and a degree there.
Not all, my lord. Lordship has disclosed one petition I know. There we had proposed a joint verification,
Yes.
but it was not acceded to.
Hmm.
Before forcing our bulldozers, my lord, we had proposed, but it was not accepted. It depends, my lord. Case wise, it varies.
The moment they don't accept that part, that we will go for a joint verification.
There is also a, my lord,
We have our
direction
own
of
assumptions.
a coordinate bench. It's a mandate.
Hmm.
314 of 24. We follow it everywhere. Joint verifications are and in some cases, the petitioners are also involved. Come and see.
It is all about coordinates. Geopositioning coordinates, and the matter is done with.
Well,
May I pay for part?
In the month of February, part heard as of today. Are we allowed? Go through the
Okay.
notifications.
Heard the matter at length.
We have not heard it. We have not heard it as of yet.
Obliged, my lord.
Yes.
Obliged.
Without the affidavits, how can we hear?
Obliged.
Orders 34.
That time is 51. No, no, totally given answer. 50. 51. Okay.
Please, your lord.
Ah,
But the brief was taken back in the year 2020.
in the year 2020.
Year.
That a yes. What was the prayer for? It is good to see the green papers once again.
But file in year 2020, 2014, your lord.
Ah, the green papers.
There is also an order
Yes.
of Lord PP Kotoki.
Huh?
PP Kotoki.
Impleading?
PP Kotoki Lordship order.
Saying?
To reinstate the petitioner and clear all the back pages. Sir. There is no interim.
A change in the management must have.
Yes. I think it is closed. Try to contact the last known manager, but we tried to contact the last known manager, your lord, but we couldn't contact.
This is a writ petition of the year 2014 where the order and award dated 27/12/2010 passed by the labor court had been challenged. Full stop. The interim protection prayed for by the petitioners was rejected on 5/3/2014. Full stop. Thereafter, the matter was listed on 3/33/2017 and 14/11/2022. Full stop. The petitioners were given the opportunity of curing the defects with regard to the notices required to be served upon the respondents. Full stop. Today, none appears for the parties and there is no representation on behalf of the petitioner, although Mr. S. Gautam appears and submits that the brief had been withdrawn by the client from them in the year 2020 itself, and therefore he is also without instructions. Full stop. In view of the above, this writ petition is closed. It appears that in view of the above, it appears that the petitioners are not interested to pursue the cause in the present form. Full stop. Accordingly, this writ petition is closed as not pressed. Full stop. Will do. No liberty required now.
I think 35.
Please, your lord.
That ECR call for be returned to the be returned for it. Yes.
Please, your lord. In this case, we have filed an IA, lordship. And accordingly, we to impede respond number 12 and 13, lordship. We may be allowed to accept.
Have you been allowed?
No, lordship. Actually, it was supposed to be listed today along with the contempt case.
Yes, it is listed. Oh, this is disposed of. What was that IA number?
IA PP73 of 2025.
That is already allowed. He was required to file amended cost title. He filed.
You filed the amended cost title?
Yes. Now he has to take sale.
By an ordered by an order dated 3/6/2024. the respondent number 10 and 11 were arrayed as parties to the contempt petition. Full stop.
No, 12 and 13. 12,
Ah.
12 and 13.
No, you take this. By an order dated 27/10/2025, passed in IS civil number 3373 of 2025, comma, respondent number 12 and 13 were directed to be impleaded as party respondents in this contempt case, full stop. Accordingly, you take this name, you take these two, huh? From the order dated 27/10, there are two names, a paragraph 3. Accordingly, so and so are now impleaded as party respondents number 12 and 13 in the present contempt case, full stop. Have you filed the amended cost title?
Yes.
Where?
Office note dated 13/11/25.
Accordingly, the amended cost title has also been filed incorporating the names of the respondent number 12 and 13, full stop. Issue notice to the respondent number 12 and 13 by speed post. Full stop. Petitioners to take steps within a period of 3 working days from today. List after 4 weeks on a date to be fixed by the registry for service report, full stop. Yes, you are also required to bring some instructions.
On the last occasion,
Huh?
we
The
have
the other persons who are already impleaded. Yes, what have
now
you
the
done to
respondent
come?
number 10. I represent respondent number 10 so
What
far.
has he done?
He is no longer in this.
He
holding the
was
post.
there.
He was there.
What did he do?
So he did what my lord, earlier there was a writ-appeal file against this order that was got dismissed. Thereafter, a high power cabinet committee is constituted. Matter was placed before the committee. We are awaiting instructions from the how the amount will be paid. They are going to verify and thereafter to take.
Have you stated that on an affidavit? That this is what we are awaiting for, this is what we have done.
Already we have
During my
filed-
term, your affidavit
Yes,
is on
yes, yes,
record.
I don't-
List after hey dilu to? List after 4 weeks dilu to? Huh? Yes. Either we have to give your photograph or you have to tell your name.
Kind of
Affidavit in reply, have you filed? Yes.
appearing on behalf of AR Patiri.
Yes.
Yes, and I has been filed for implementing the Napam Lilabari Model Anganwadi Center represented by the Secretary as Respondent 7 in the UPC number 3952 of 2016, which is pending for disposal.
The IA is pending.
Yes.
Koনখন IA pending আছে sir? You want to implead whom?
Respondent number 7.
Who is his name?
Napam Lilabari Model Anganwadi Center represented by the Secretary.
What is the matter about? What is
Yes.
the matter about?
Matter is about demarcation of the land of the petitioner.
So why is it pending from 2016?
Yes.
Affidavit has been there, madam.
Why did we require this? Why do we require this impleadment?
Oh, copy has
Implement
been forwarded.
Annexure A of the I. Annexure A. Yes.
No, we are not
Is
on
number
that.
11.
We are not on that. This matter came up in the year 2016. Then it came up in the year 2019.
Yes.
Now today it has come up after 6 years.
Yes.
Respondents have filed the affidavit in opposition
Yes, yes.
and yes,
Filed by
tell
circle
us.
officer as well as the DC. if I'm not
Yes.
wrong, my lord. Additional DC and my lord circle officer.
Why the demarcation cannot be done?
Let's just come to the para 11, my lord.
Yes.
It says, my lord, that with regard to section in paragraph 14 of the writ petition, the deponent victim as per record, tag number one.
Whose affidavit?
DC, my lord, additional DC.
Ashraful Amin. Respond number 3.
Yes, Master.
Sorry.
Yes.
Para number?
Para
Sorry,
para number 11.
Wait,
Yes. It the for demand that but now government has brought it demand that notified that Assam right service. It is apply online. The state should take
What
care.
do you say, madam? Otherwise, it will only be from 2019 today. You have remembered because the case has been put on list. If we close this writ petition, giving you the right and giving you the liberty to move an application under the format now available, they are bound to do it within a particular period of time. 30 days.
But may take another, so that's my senior.
Please take down her to Miss So-and-so, learned counsel appearing on behalf of Mr. K.R. Patgiri, learned counsel appearing for the petitioner.
Maybe pick the next.
Yes. Also heard Mr. Das and Mr. Bhattacharya, learned counsel appearing for the state respondents. You would also appear in this matter? Full stop. This writ petition is of the year 2016, wherein a prayer had been made by the petitioner for demarcating the land described in the writ petition. Stop. The notices in this case was issued on 11/7/2016, and it was thereafter listed only on one occasion, that is 25/2019. Today, the matter has been put before this court after nearly 6 years, 6 years on the basis of IA civil number 2506 of 2025, whereby the petitioners pray for liberty to implead a fresh respondent to the writ petition. Full stop. The learned counsels appearing for the respondents have submitted that as of today, the petitioners are at liberty to apply for demarcation of the land in issue under the Assam Right to Public Services Act 2012, which also provides for time-bound action to be taken on behalf of the respondent authorities. Full stop. The learned counsel appearing for the petitioner has prayed for an accommodation till the next week to have her instructions on the matter. Full stop. List this matter again in the next week.
It may be given.
Did you? Where are they? Next week, where are they? Did you? Again on so-and-so, whereupon the petition, counsel for the petitioner shall have her instructions and a full stop. The state respondents have filed their affidavit in opposition, and the petitioner has also filed the reply, full stop, and attempt reply, full stop. Making that video. Yes.
1937.
Very big. Yes, madam.
Your Lordship, the steps upon the respondent number 9 has still not been completed yet.
So,
Your Lordship, we have taken time so that we can take his current details of whether he has been posted or
what's the matter about madam?
Our investigation has been done. This is the matter.
Huh?
Proper investigation has not been done. In fact, my lord, we have filed an affidavit in 2020, my lord, 17/12/2020. In that affidavit, we have stated that my investigation was going on, my lord.
Going on then?
And my lord,
There must be some
after-
PS case number.
Yes,
Your Lordship.
yes, my lord.
There must be some PS case number.
Yes, my lord, yes,
This
my
is 785 of 2019.
Any?
After that, my lord, case was dismissed here, only this, my lord. I have-
No, no, maybe you can find out what, whether charge sheeted or.
Yes, my lord, that is my.
But once the PS case has been registered.
Yes.
Are we to look into whether the investigation is correct or not? Can we look into that, madam?
No, my. That is the another file is there, my.
Huh?
For that purpose.
Tell us something. Your prayer is?
There is for proper investigation.
You are praying for appropriate action and arrest of the accused person immediately. That immediacy is gone.
Yes.
How many years? 5 years down the line, he has not been arrested. Nothing has happened.
Earlier 156 chapter the proposed before the matter concern.
Find out if there is a charge sheet, if there is an FR. If there is a charge sheet,
Yes.
all is well that ends well. If there is an FR, then make a complaint there.
Yes.
Maybe the petitioner has appeared, accepted the FR. You are still taking steps here. Protest petition, huh?
Sakari Basumaka.
Protest petition.
Protest.
No, they call it something else. Narazi petition. Narazi petition. Hum razi nahi hai, huh? So what do you do? When can you have that instruction regarding this dispute PS case number? Huh? One phone call, 10 days.
No matter 1 week, matter next week, matter I would take.
This writ petition had been initiated, heard Ms. So-and-so and counsel appearing for the petitioner, also heard Mr. So-and-so and Mr. So-and-so and counsel appearing for the respondents. This writ petition had been initiated in the year 2020. Praying for directions to the respondent authorities to take appropriate action with regard to dispute PS case number 785 of 2019 under section 420/406 of the IPC and to arrest the accused person immediately. Full stop. An affidavit in opposition had been filed by the respondent state stating that the investigation was being conducted and my investigation was still being conducted. Full stop. Today, Mr. Hazarika has submitted that he may be allowed opportunity to
Get
up to date status.
Status of
Full
the
stop.
incident.
List this matter again on Friday next week. 12th of December 2025, by which time appropriate instructions regarding the fate of dispute police case number so-and-so under section 420/406 of the IPC shall be placed before this court. In the meantime, the learned counsel for the petitioner shall also have instructions as to whether any further adjudication is required in this writ petition.
Item 28.
Yeah, please, Your Lord. I am on behalf
Yes.
of M. Rana.
Huh?
I am on behalf of M. Rana.
Yes.
As per last order, 28/11 to 25, that a step was taken.
What is that order that you want compliance of? 11/12/2019. Where is that order?
Hey, my lord, one thing I am like wanted of my lord.
Please.
Because my lord, in this case, my lord, only issue to the respondent number notice against the respondent number 6 has been issued. In fact, my lord, notice against the respondent has not been issued.
To the other respondents.
For other respondent.
Ah.
Because my lord, initially they take time to implement the respondent number 6 and so maybe mistaken, my lord, but notice was not issued, my lord. I have also not taken any step for.
No, no,
and
you just.
I have taken the order.
No, you just tell us there is a there is an order of 11 December 2019 by which the Commissioner of Central Assam Division had directed that the PDS system to him shall be restored. He is saying that yes, please restore it according to that order.
Because my lord, no communication has been made because there are no because notice was not issued. My lord. It is
Does
like-
the cause of action survive, sir?
Yes.
Can you run the PDS system now?
He have to take instruction, I don't know.
Huh?
I have no. I am only here on behalf of M. Rana.
Let him take my lord.
Yes, can you tell us why you have not taken steps on respondent number 6?
It was taken, my lord, on 4/12/2025.
No. You did not take your steps up till 28/11/2025. Is it not? Tell us why not. We don't think we need to pursue with this writ petition. We do not see any reason to do so. Not necessary. Notices were issued when?
Actually, my lord, notice was not.
Just a minute. Matter is adjourned for a week. Then? Here you IAS in Niki.
One I was.
Huh? Shows the I. What's the Where is that order requiring issue? Take down. This writ petition was initiated in the year 2021. Where? On 7/9/2021, that is the first date of listing, a prayer was made on behalf of the Learned Counsel for the petitioner to adjourn the matter for a week, full stop. Thereafter, an interlocutory application was filed for impleading a new respondent to the writ petition, and the same was allowed, full stop. By order dated 1/11/2021, notice was issued on the newly implemented respondent number 6 by registered post with AD within 3 days, full stop. The steps were taken on. Now, notice was issued to the respondent number 6 by registered post with AD on 15/11/2021 and by an order of 21/6/2023, the Law Azima Court had directed that the matter be that fresh steps be taken for issuance of notice upon respondent 6 by registered post with AD, as well as usual court process to the office of the Learned Munsif Nagaon within 10 days from the date of this order, full stop. The office note dated 31/10/2025 reflects that no steps had been received till that day. Full stop. The order dated there was another office note of 28/11/2025 that no steps had been received by the section so far. The Learned Counsel appearing for the petitioner has submitted that steps have been taken on the respondent number 6 on
4/12.
On 4/12/2025. That is yesterday. Full stop. Notices have not been yet issued on the other respondents, and it appears that there is no interest of the petitioner to pursue the writ petition. Full stop. You're taking the steps is also not helping because he has taken it by registered AD. Now the registered AD will not be accepted. How did he file it? Full stop. List this matter again on Tuesday, dear. On Tuesday. By which time the learned counsel for the petitioner shall ascertain whether they intend to pursue this cause of action at all. Full stop. We are not dismissing it only because
Highly obliged.
we'll do it on Tuesday. You can have the other counsel standing here.
Highly.
You have not even got the notice issued for the last 4 years.
Today, my lord, I am appear.
So let him be here. We'll deal with it.
Item 41.
My lord, I appear for respondent number 1 and 2, my lord.
Yes.
Wait,
My-
I am appearing on behalf
Sakra, let her.
My lord.
on behalf of the
Tell us.
kindly allow time to file a affidavit in reply lordship.
The affidavit in opposition was filed on 15th of September, madam. What is the prayer in the writ petition?
My lord, there is nothing which survives in this writ petition as of now, my lord. My lord, we are a transmission company. We are a public sector undertaking. We are constructing a transmission system. So initially, my lord, they had misconstructed an order as being an interim stay order and they have stalled the project. However, my lord, the Honorable Court was pleased to clarify on that order, while order dated 24/9/2025, my lord. And since then, my lord, this particular stretch of the area's work is almost completed. So we are in the process of making the assessment for payment of the compensation in terms of the Electricity Act, my lord, Telegraph Act, and the allied guidelines, my lord, if any, which are applicable to them. So if they are aggrieved with the quantum of compensation, my lord, under 16(3) of the Telegraph Act, they can go and initiate the process in front of the district judge for enhancement if they are not satisfied with the quantum as has been given.
They
my
have
lord.
been paid some compensation on this.
My lord, there was no work which was done. So after the order, now when the work is being done, we have started the assessment, my lord, because the damages have to be quantified as we do the construction. So we will be paying them the compensation as per law, my lord, because the circle rates will also have to be taken from the concerned state revenue authorities.
The assessment is now going on, and if they have a grievance against the assessment, they can go to the appropriate forum.
My lord, as per the Telegraph Act under section 16(3), it is the district judge who is the appropriate authority, my lord, for them to go for if they are not satisfied with the quantum of
You want to
compensation. my
file
lord.
affidavit in reply?
Yes.
By what time?
After vacation.
We'll have it in the month of January,
My lord.
by which time you may file your affidavit in reply, failing which the matter will be taken up for consideration with or without the reply. Will that do? Heard Ms. So-and-so, learned counsel appearing for Ms. Tisom, learned counsel appearing for the petitioner, who submits that she may be accommodated for 2 weeks to file the affidavit in reply to the affidavit in opposition filed by the respondents. Full stop. Mr. Khera, learned counsel appearing for the respondents, have submitted and have shown urgency in the matter since it relates to the installation of towers under the Telegraph Act. Full stop. Place this matter again on February 1st week, did you know? 3rd of February 2026, enabling the petitioners to file their reply if any. Full stop. It is made clear that the matter, if no affidavit in reply is filed by the said date, the matter may be taken up for consideration even in the absence of the reply. Yes.
My lord, I'm for respondent 1 and 2 only.
Respondent number 1 and 2, Mr. Khera. Respondent number 1 and 2, Mr. N. Khera.
And my lord, the affidavit also has come from only 1 and 2.
Yes.
Item 42.
Highly obliged, my lord.
It will be
May I please, my lord?
Yes.
Here, my lord, we have taken upon the steps upon the response number 1 and 2 by today, my lord. So this is the Reserve Bank of India, my
Against the Reserve Bank of India.
Yes. But here we are the Bogitala Tea and Trading Company, my lord. From the account which was freezed by the respondent, my lord, from that we are paying to our tea workers. This is the account in operation, my lord. They have freezed this account time to time, my lord, due to the KYC update, my lord. So they asked for some certain documents. We have provided all except one, my lord. This is the corporation certificate, my lord. If you kindly peruse, my lord, order dated.
It is like saying that we have provided all the documents except the birth certificate.
My lord, that law. My that explains.
If you are not incorporated.
Page 39, kindly peruse, my lord.
No, we are not passing any orders. What do you want today?
Let the RBI appear, my lord.
You are for?
May I please, Lord. So I am appearing for respondent number 3485, which is Axis Bank debit.
Okay.
Now, your lordship is aware that Reserve Bank is the guardian of all bank and financial institutions in India. So on 13/9/2023, this Honorable Court has passed an order directing them to take steps on respondent number 1 and 2 immediate.
With all the faults on their part for not taking the steps. They are usually known to be vigilant lawyers. So I think we can afford them one opportunity.
But whether still they are entitled to continue with the benefits of interim relief lots.
What is the interim relief?
Yes, lots.
What is the interim relief?
I'm coming to that lot.
No, just tell us. We have to be quick.
As I have started lordship, Reserve Bank is the guardian of all banks and financial institutions in India. So Reserve Bank from time to time circulates its policy towards all the banks, asking them to get the re-KYC documents from its customers. So if your lordship kindly turn on page number 27 of the writ petition, that is their document, lordship. Page number 27, annexure 1 of the writ petition.
We will ask you another thing. You are a bank.
Yes.
And you want to freeze the account of the petitioners.
We don't want to freeze, lordship, until and unless they provide us the required document as per RBI guidelines.
No, they have not provided you the required documents, so you want now to freeze their account or what?
Lordship,
do you want to freeze their account?
It was initially
it was reopened. Your
as
bank
per
is
order.
getting business.
From time to time,
You want it to be freezed again.
Lordship,
if you want it to be freezed again, then you have to comply with the order dated 13/9/2023, which says that without obtaining the leave of the court, please file an I. We will look into it.
I got it.
Is it not? You can freeze it, take our leave.
Every time the system freeze it, because it is a computer generated system.
Cannot.
We just reopen it.
You cannot, because the court has directed you, change your programming or take the leave. Either of the two.
Yes, sir.
Take leave.
Yes.
We may allow.
I will try my luck.
Mr. So-and-so learned counsel appearing for the petitioner has submitted that. You have taken the steps or not taken steps?
Yes, I have taken steps today.
That steps on the respondent number 1 has been taken today.
Well,
and he prays that he may be allowed to it has been taken today, full stop. In view of the submissions made, list this matter again after 4 weeks with service report. Anything else?
there is an
To the extent of what?
not to freeze the account operated by the company.
Which date? Now we will exceed the court time and therefore there will be costs. Yes. Which date? Interim order to take our file. Trace out the interim order. Tell us. Yes, next to matter. Yes, sir.
May I please, sir? My lord, order dated 11th of August 2023 is not complied with, my lord. And pursuant to the order of
Yes, the Deputy Commissioner, who appears? Deputy
None
Commissioner
appears.
Dhubri. Notice was issued.
Notice was
Like A. Yes, sir. Deputy Commissioner sending us letters. We don't want to comment upon it, but kindly see if the contempt continues or not. You also go through it. There is an order passed by the Deputy Commissioner.
but we have not
Flag
got any
A.
communication.
We'll give you a communication, but we have to close the contempt if there is an
Yes.
order passed. Flag A, please go through. Does it suffice the contempt? Next to matter, please. Huh. Yes, sir.
Non-payment of contracted.
Hmm.
Direction of the Channel Court.
RR Gogoi, what is the department? PHE.
PHE.
Scroll Diok. Yes. PHE. Close this. You have paid.
Yes.
Payment done. Show him. Show him.
Four lakh 30.
Any other, if he has got a grievance on that, they will agitate it before the appropriate forum, is it not? Huh? Yes, sir.
4 lakh.
Hmm? You were required to be paid 5,21,000 something. TDS deducted 4 lakh something. Any further claim, appropriate forum of law.
Direct in the
Page 10.
page 10 year.
Yes. 5,21,727. You were paid 4 lakh something. After TDS. Yes, give me that.
I do not have such.
Sorry?
I do not have such. Yes.
The grievance of the petitioner in this contempt petition. No, the grievance of the petitioner. The complaint of the petitioner in this contempt petition was non-compliance of the order dated 9/4/2024 passed in WPC 2147 of 2022, by which this court had required the respondent number 3, that is the chief engineer PHE, to verify the claim of the petitioner and proceed in accordance with law within a period of 1 month from the date of receipt of a certified copy of the order. Full stop. Today, Mr. I. Bodhakur has placed. What is this?
Then give it to the accountant general to release the amount, and then we have been informed that it has
A communication dated 18/8/2025 issued to the accountant general within bracket ANE Assam by the PHE department for release of an amount of rupees 4,39,114 to pay the entitled amount to the petitioner in accordance with the orders passed in WPC number 2147 of 2022. Mr. I. Bodhakur submits on instructions that the amount has also been released to the petitioner. Full stop. In view of the above, this court does not find any non-compliance of the orders of this court, save and except that it has been complied after the time frame granted by this court. Full stop. However, therefore, this contempt case is closed on compliance. Full stop. Mr. So-and-so learned counsel appearing for the petitioner that states that he does not have instructions about the receipt of the money. Full stop. In case the order has not been complied with, the petitioner would be at liberty to bring the same to the notice of this court and re-agitate the contempt case.
Right. Awesome.
Next matter.
Complied.
Hmm? Complied, na?
Complied in negative, my lord.
Eh?
The order to be passed by the respondent shall be communicated to the petitioners forthwith, but we have not been communicated.
So we'll send them to, we'll hold them for contempt on that.
No, my lord.
Not
I am
necessary.
not asking
Okay.
for that, but
Mr. AFNU Mullah, Commander Counsel for the petitioners, has been provided a copy of the order dated 22/3/2024. Have you been provided a copy?
no, not
Okay.
provided.
Has gone through a copy of the order dated 22/3/2024, which is found on record of this case as Annexure A. And in his fairness has submitted that the requirement of this court in WPC in order dated so and so in WPC number so and so to pass necessary orders has been complied with. Full stop. However, he says that the said orders would be required to be agitated since they do not satisfy the claim of the petitioner. Full stop. Mr. N. Das, learned government advocate, has been is directed to communicate with the office of the District Commissioner, Dhubri District, Dhubri, to obtain a copy of the order dated 22/3/2024 and pass on a copy of the same to the learned counsel appearing for the petitioners for his doing the needful. Pass on to the petitioner for his use.
Can be, it's only a submission. It can be passed in history also. They will approach they will duty bound to serve the copy of the.
Okay.
My lord,
You strike out that part. Yes, you write it like this. Mr. Mullah has also submitted that the petitioner has not been supplied with a copy of this order. Full stop. The District Commissioner, Dhubri District, Dhubri, is directed to provide a copy of the order dated 22/3/2024 to the petitioner immediately on his approach. Full stop. It is also noted that the letter dated so and so has been sent to the registry directly. The District Commissioner Dhubri shall ensure that no further communications are sent in any matter to the registry of this court, save and except through the standing counsels for the department. Yes.
Obliged.
Closed. Contempt is closed. Yes, what is the interim order?
My lord, that 13/9/2023 order, my lord, despite that they have violated it, my lord, order, my lord, we have filing contempt also, my lord. Contempt petition number 688/2023, my lord. It is on the, my lord, not listed for the report. So therefore,
So does that interim order need to be continued?
no,
No.
sorry.
Cost of rupees? Per minute cost, yes, wasting the time of this court. No.
Kindly please this contempt along with this, my lord.
List
We
this
have
matter
already
along with
completed the
contempt case number so and so,
688
order.
All right, we'll close it on the next day. He wants it on board.
Both may be taken.
Huh?
Both cases may be taken.
List this matter along with contempt case number
688/2023.
688 of 2023. Let them come up together, we'll close it.
Obliged, lord. Obliged.
Go through the interim orders before you press for a
My
continuation.
lord,
It may be to your disadvantage. We'll say till the next date fixed. You are
I'm sorry. Obliged. Obliged, my lord.
Date di thua asil niki kiba?
After
After 4 weeks koisilo. List after 4 weeks koisilo. Yes.
Obliged.
None appears for the petitioner on call. Full stop. None appeared before the Loazima court also when the matter was taken up regarding the service of notice. Full stop. List the matter again after the ensuing vacations, giving one opportunity to the petitioners to enter appearance. Yes.
Item 46 and 47.
The direction of demarcation, ma'am. And that the demarcation in respect of the petitioner land was not done, although there is a direction of honorable court.
I have
Now,
My lord,
now,
the friends
why they
are-
cannot do so, my lord? Let me show one page 68, my lord. Their measurement and length of their visa is just 1 minute. 1 bigha, 4 kata 7 lesa. They got demarcation of 4 bigha, 3 kata 12 lesa. So how can they get a demarcation of this? That is the things, my lord. Kindly see page 68, annexure N of
Okay, number item?
46, my lord.
6 and 7, yes.
5.6. Here, their patta line is 1 bigha, 4 kata 7 lesa.
Sir, let us be practical with around 7 to 8 minutes remaining today.
My lord.
My lord, let it come on. My lord, I am.
They have to,
My lord,
they have to
what
collect the report, my lord. They cannot collect report after 20 years also because of these things. The land is not that with them, but they somehow managed to get 4 bighas land.
My lord,
So that is a very serious matter, my lord. If it continues, the my lord, prima facie,
my lord, a power of attorney holder.
they are the beneficiary of the government, my lord.
Please, the IA is filed by me, my lord, because my lord, I am the person.
IA concern?
IA is for my lord, getting my name muted. My father expired. My father was the party. My father has expired. Now I have become a party to the proceeding. I have filed for mutation. My lord, they are not giving me mutation because of this writ petition. There is no stay order, and he files an objection. I just
remember.
I-
This matter was before this court
Also, my lord, this
on an earlier occasion.
yes, my lord, your lordship has allowed that IA for my name to be impleted. Now, my lord, my IA is for getting my name muted. My lord, just one thing, my lord, I can place his document. My lord, demarcation can be claimed by a person who has a right and who has a position. He doesn't have a right, my lord. I'll show all the government documents. He doesn't have a right, my lord. His land, my lord, he has annexed some documents, translated few portion of the original document, and the others he is showing the English text.
Have you filed your affidavit in opposition
About what, my lord?
On this?
The I filed for my name to be muted, my lord. What is the problem?
So in that IA,
Well, you can
have you given the correct and complete English translation of the documents produced by him from where we can understand?
my lord, that is in the writ petition, my lord.
So that he has
My lord,
translated.
because that IA is not related
sir.
to his pair, man.
Sir, the portion that you are saying he has not translated,
My lord.
if that is an important portion for us to read, it has to be in the translated
My
form.
lord, that I will give it, my lord, when we going through the writ petition. My lord, this IA only for my name.
Allowing your name to be mutated now.
Will not, because he doesn't have anything to be
That will
done.
be deciding his.
No, he doesn't
claim
have a
also.
right, my lord, because the
So that-
circle office is.
So the moment we say that we are deciding the writ petition, can we do that, sir?
No, all right, my lord, your lordship will fix it on.
Can it be fixed next week?
That is what I was saying.
Let it be, my lord,
And in
Thursday.
the meantime, you get the correct translation.
My lord, I will give the
version.
Let it be on Thursday, my lord. Next Thursday.
Huh?
Next Thursday. 11.
At the request of the learned counsel for the parties, list this matter again on the 11th of December 2025. Kindly provide a complete translated copy because we trust.
Yes.
And if the up and down portions are something against you, we trust you to bring it again, bring it
Actually,
to our notice.
Yes, my lord.
There are two ducks.
205 and 207.
What of us earlier some bit said comply with regard to the
For 202.
last occasion it has been submitted. The limit 202 has been demarcated. 205 has not been.
Yes, we read that order.
I have got a record. But 205 was
Demarcated. But show it to us on the next date. Yes, mediated. Was it mediated, sir? Huh?
Profit manner.
Huh?
Union of India should have been at the top because Union of India has issued the eviction notice.
Yes.
But in any case, talk about
They had gone for a mediation.
mediation,
No, is the Union of India a party at all?
railway,
Railways.
they're sitting on railway land.
Ah.
They had a license and even some petitioners don't have a license also. They are petitioners here.
this is at 6092 of 2024.
Yes.
Shall we have it immediately on the reopening, giving them one opportunity to be present?
Yes, Lordship. There is some urgency.
They're
Let it be in the first week of that.
None appears for the petitioner on call today. Full stop. Mr. RKD Chaudhary, Learned Council, Learned CGC, Learned Deputy SGI, has appearing for the respondent number 2 and 4. 2 and 4.
Yes.
2 and 4 has expressed urgency in the matter. Full stop. List this matter again in the immediately on the reopening. Immediately on the reopening. Immediately on the reopening. Full stop. Mr. So-and-so appears for the respondent number 1. And he is a deputy commissioner. Yes. 7 January.
Item 49.
Respondent number 2 has appeared. Respondent in respect of respondent number 1, he has left as per office note. And 3-4 service report regarding contractual.
Respondent number 2 appeared. Unserved notice. Return to sender. One is who?
Commission.
Maybe he has left office by this time, and therefore it was returned to sender.
210 of the tweet.
Yes, this was regarding what? What was the required to do?
Non-payment of contractual bill.
Yes, you are the only person.
Yes. Regarding
unfortunately, yes. Any instructions?
Lordship, kindly take up after package. Kindly take up after package.
After vacation. But
in the meantime,
payment of the bills before the vacation will help him more.
Yes.
Or immediately after the vacation may also help him.
In the meantime, we'll file it.
For vacation is possible. Not possible.
No, not before the vacations. We'll have it on the 8th of January. On the 8th of January. Mr. So-and-so Learned Council has entered appearance on behalf of the respondent number 2 and prays for some time to file their response to the contempt petition. Full stop. List this matter again on 8th of January 2026. Full stop. Service report on the respondent number 3 and 4 and 5 will also be.
There is no 5. Respondent number 5 is not.
3, 4 and 5 is written here.
There
in
is
the
no
office
5
note.
that.
3 and 4 koi diyo. 3 and 4. Okay, done. Over. Thank you.